All right, good morning, ladies and gentlemen. My name is Judge Law, and we are going to begin with our all-purpose calendar with the State Court of Fulton County. This is including criminal misdemeanor cases in which individuals have already been accused, bonds have been set, and today we're going to determine the status of their cases. Some individuals plan to enter a not guilty plea, and their cases will be scheduled for trial. Others may consider a plea offer from the prosecution and enter a guilty or not no contest plea in exchange for a recommended sentence. Others may consider bond modifications, or we may also address probation revocation cases. If you are a defendant involved in any of these type of cases, please remember that you have a right to remain silent. Anything you say during the course of this recorded and live stream proceeding, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. I have Mr. McLean and let me see, Mr. McLean and Ms. Vigiletti. I don't think I have printed. I'm looking at the multitude of paperwork I have here. Yeah, I don't think I've printed your announcements. I do have it. No, it's my bad. I didn't print it, but it's until I get a printout, I'm just going to count on you to tell me how you'd like to proceed. Okay. Which case would you like to begin with first?
Oh, let's see. We have add-on Sharon Compton at ACDC. Is that available as a video feed right now?
We are ready.
All right.
Morning.
Good morning, Deputy Milton. Thank you. And Mr. McLean, who is this again, please? I'm sorry. In what position number?
Sharon Compton is add-on. I think it's the only add-on, so we'll call it add-on number 1.
That sounds logical. Thank you very much. Okay, Ms. Sharon Denise Compton is at Fulton ACDC, accused of 3 counts of criminal trespass causing damage to property from March 11th, 2024. Ms. Compton, your case number is 24CR 001141B. You have been advised of your right to remain silent, and your attorney is Mr. McLean. Mr. McLean, how are we proceeding today?
It is my understanding that Ms. Compton wishes to enter a negotiated plea of guilty.
All right. Mr. Pierre Thomas, is that your case? I'm sorry, you're mute, sir.
I can handle the case, Your Honor. I don't believe that I've received the add-on calendar, but I'm sure if you would just give me the case number again, I can look it up.
24CR 001141B.
Okay.
Mr. Thomas, this is a reset from Tuesday, so we do have an offer from Tuesday.
Yeah, and I think it should be in my system since it's a reset. Give me 1 second.
Great.
All right. Sure. She gave me her number the other day. What is it?
What's your name?
Mhm. Right, I know they are, and I know the restitution amount.
Are we ready, Mr. Pierre Thomas?
I will rely on, as I look for the notes, I will rely on the public defender's office for the offer.
Okay. Mr. McLean, if you have the time, I'm looking for the calendar from Tuesday. I don't have it readily available to me.
Yes, Your Honor. The state had mentioned count 1 as being 12 MP, which stands for months. Serve 60, credit 16, probation, stay away from North Island Avenue, specifically the address at 746 North Island. $100 restitution to Mr. Colton and no contact with, I believe it says Rachel Levy. Count 2 was going to be a $530 restitution. Otherwise, it was simply 12 months concurrent with count 1 as probation. Restitution is to Ms. Levy and no contact again. So that repeats it. Count 3 was going to be restitution open for 30 days, 12 months probation concurrent, and no contact with Thornton Morris. Thornton Morris, Thorton, not Thorn.
Is that consistent with the state's request?
One moment, Your Honor.
Your Honor, I believe that as it relates to the state, that was position number 9 on the calendar from 3/26.
Yes,
And as I have it, count 1 was 12 months probation to serve I have to serve 60 days credit for time served. I am showing that she served 16 days. So then the balance would be on probation. Stay away from 746 North Highland Avenue Northeast. I'm showing a $100 restitution to Ms. Russell Colton.
Mhm.
No further contact with Rachel Levy, Levy. Count 2 was 12 months probation to run concurrent with count 1 with $530 in restitution to Rachel Levy this time. And no further contact again with Rachel Levy. And count 3 was 12 months probation concurrent with count 1 and count 2. And I believe the restitution was to remain open for 30 days to a Thornton Morris. And no further contact with Thornton Morris. So that is the recommendation that I have.
Your Honor, being 2 days later, the credit would adjust from 16 to 18.
That is correct.
So how many more days does she have for the jail?
30 is half of 60, so 18 from 30, I believe, is 12. Used to be.
All right, let me just confirm that. 1632. It's 28. I've got 14 days.
Right, with the 16, it would be 14, but today it would be now 12 days to go.
Oh, you're correct. Yes. All right, then I'll proceed. Oh, shoot. Okay. Miss Compton? And first of all, Mr. McLean, do you stipulate to the factual basis, venue, and ID?
For the purposes of this plea today, Your Honor, we do so stipulate.
Okay. Ms. Compton, have you consumed any medicine or alcohol? And Deputy Milton? Yes, please. Thank you.
Hold on. Okay, go ahead now. No,
All right. Ms. Compton, have you consumed any medicine or alcohol?
no,
Was that a no?
yeah, I have not.
Okay, good. And have you understood what's been going on in your case so far?
Yeah,
Are you satisfied with your attorney?
yeah,
And is anybody forcing you to plead guilty today instead of going to trial?
no,
If you decide to plead guilty to these 3 counts of criminal trespass causing damage to property, you'll be having to serve additional jail time. After that, you'll have to be on probation so you can pay off these 3 individuals for the damage done. Are you prepared to do that freely and willingly?
as long as I know the
Okay.
time, yeah,
You understand that you have to pay back $630 to Rachel Levy and Thomas, I think his name was Colton, Rachel Levy and Russell Colton.
And Thornton Morris is open.
Yeah, and that you would have to pay additional money to another individual called Thornton Morris.
Okay.
Is that what you understood your
Yeah.
sentence to be?
Yeah.
Okay. And did your attorney explain to you that if you have to plead guilty to these 3 counts, you will not get a chance to have a trial in a court of law? You will not have a chance to come back into a courtroom to face your accuser, to be able to challenge the evidence brought against you, to present any defenses and mitigating factors you may have, and have the state try to prove the charges against you beyond a reasonable doubt. You would have to waive all these constitutional rights. Was that explained to you?
Yeah.
Are you prepared to waive these rights? Are you prepared to give up these rights and plead guilty to the 3 charges brought against you?
Yeah.
How do you plead to 3 counts of criminal trespass causing damage to property?
Just guilty.
Repeat.
Guilty.
Your sentence for count 1 is 12 months to serve 60 days, credit for time served 18 days. You have 12 more days to serve at the Fulton County Jail. Once you have completed the 12 days, you must report to probation on the first business day. The probation office is located at 132 Mitchell Street in downtown Atlanta. While on probation, you will report to probation every month. You will have no contact with Russell Colton, Rachel Levy, and Thornton Morris. Do you understand?
Yeah, so I served 12 days.
You have 12 days at the Fulton County Jail, and once you're released, you must report to probation.
Okay. Yeah.
And you will report to probation every month,
Okay.
the rest of the 12 months.
Yeah. That's fine.
You are to stay 200 yards away from Russell Colton, Rachel Levy, and Thornton Morris. Do you understand?
Yeah.
I don't sound so convinced. I'm
Yeah.
not so convinced that you understand.
I
You
understand.
understand that you have to pay these people back.
Yeah, I understand.
Okay. Maybe if you sound a little bit more sure, I'll be more convinced.
I understand.
Good.
I heard what you said.
Now you sound like you understand.
Yeah.
For Russell Colton, you will have to pay him back $530. For Rachel Levy, you have to pay her back $100. And your case is going to remain open for another 30 days. You may have to come back to court to hear how much you owe Thornton Morris, if anything at all. Do you understand?
Yes.
You must start paying back this restitution. You pay the money directly to your probation officer. You don't pay it to these individuals. Do you understand?
Mm-hmm.
And the first payment of $50 must be made within 30 days of being released, and you must pay $50 every month that you report to probation until everything is paid off. Okay? If you understand all that, then we are done.
Yeah.
Thank
Your Honor, I'll just make a quick correction as it relates to the restitution, Your Honor. The $100 is to Russell Colton and the $530 is to Rachel Levy.
Okay. All
Thank
right. Ms. Grace, if you will make that correction, please. Thank you. All right. Deputy, in courtroom 2, where do I go next?
Your Honor, have a seat over there. Is it possible if courtroom 2 and medical will agree with me? May I finish my last 2 here? So
Go
I
ahead,
can go to
Milton,
my
Milton.
9:30?
Milton,
Thank
finish
you.
up. Finish up.
Thank you.
Let Ms. Vigilante know that her client is ready for the breakout in medical.
I hear you, Officer Blunt. These last 2 at ACDC are my clients, and then I'll speak to him next, okay?
Okay.
I have number 5.
Who do we have? Who do we have at ACDC?
Probation 1, Jaquavia Collins.
Thank you.
Collins is not. I just got so long. It's so cool.
All right. Yes.
Ms. Collins is represented by Maureen McLeod. I did let her know that Ms. Collins was on the calendar for today. She said she was going to try to come, but she has a jail jury calendar today, so she's not sure when she'll be able to make it this morning.
Okay, I don't know if Mr. Adams. is
If you
on.
could, Deputy Miller, call the next person, and while you call the next person, good morning, Mr. Barnes.
Good morning, Judge. How are you?
Fine, thank you. What was going to be the recommendation for Jaquavia Collins?
Your Honor, due to the time remaining on this case, probation was going to recommend that probation be continued.
Okay, just wanted to get that FYI. Thank you so much.
You're welcome.
All right, who do we have at ACDC?
Position 12, Alvin Jackson on the SAP calendar.
Okay, is that your client, Ms. Vigiletti?
It is, Judge.
Okay. And how are we proceeding, please?
I did send over a counteroffer late last night. It is fairly brief. I'm not sure if the solicitors have had a chance to review it. I'm happy to.
Okay, hang on, just one second. There is this Samsung phone where this person is not even dressed. Can we remove him from Zoom until he is dressed? Thank you. Thank you. All right. Mr. Pierre Thomas, have you received the offer from Ms. Vigiletti?
Yes, Your Honor, we have. I'm just waiting for confirmation and approval.
So we're not ready to address that case?
We are. I've gotten approval, Your Honor.
Okay, then let's proceed. We have Alvin Jackson, accused of simple battery family violence from December 28th, 2021. His case number is 22 CR 0000286F. Mr. Jackson, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. Mr. Jackson, we are going to consider a plea offer. May I place you under oath?
Yes, Your Honor.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Mr. Pierre Thomas, what's the recommendation for Mr. Jackson?
Yeah, the recommendation from the state is that the defendant is to serve 12 months, 365 days, and he can serve that concurrently with his open and active felony case that he currently has.
Ms. Vigiletti, are those the terms to which your client has agreed?
Yes, Judge, they are. So we just ask that the court accepts the recommendation of the state this morning.
All right. Is he being given credit for any additional time?
So it appears that he can get credit for 4 days. It looks like he was booked in on January 20th, 2022, and he was released on January 23rd, 2022.
Okay. Ms. Vigiletti, you stipulate to the factual basis, venue, and ID?
We do for the purposes of the plea.
All right. Mr. Jackson, have you consumed any medicine or alcohol?
No, Your Honor.
And have you understood the proceedings so far?
Yes, Your Honor.
Are you satisfied with your attorney?
Yes, Your Honor.
And has anybody forced you to enter this guilty plea instead of going to trial?
No, Your Honor.
If you decide to plead guilty to this misdemeanor charge, you would have to give up your constitutional right to a trial. You will not get a chance to confront your accuser, challenge the evidence brought before you, and have the state carry its burden and prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to one count of simple battery family violence?
Guilty.
Your sentence is 12 months to serve 365 days, being given credit for 4 days. That concludes the case.
Your Honor, if we could just sound for the victim in this case, Miss Celine Patton, CELINE PATTON. Our office has not been able to get in contact with her, but we just want to sound for her in accordance with Marcy's law.
Miss Celine Patton? No, don't see her. Yes, Mr. Jackson, did you have a question?
Yes, Your Honor. I've been in Fulton County Jail for 14 months already. So did this time run concurrent with this case?
The time, this 365 days were less 4 days, is going to run at the same time as the sentence you received in the felony case.
All right.
So it runs concurrent with your current sentences. We're not adding anything additional.
All right. Thank you, Your Honor.
Thank you. Best of luck. Next case, Deputy Milton.
Your Honor, what's the status about Miss Collins?
We don't have Miss McLeod.
Okay.
Unfortunately, if Miss McLeod was here, she was going to be released to continue on probation. So
Okay,
we can leave her there because
I'll
if
come
I
back.
reset, yeah, okay, because if
I'll
I
come back.
reset her, it won't be till next Tuesday.
Right. I will come back.
All right. Thank you, Deputy Milton. Appreciate it. Ms. Vigiletti, if you will get on your device, we can place you into a breakout with medical. And Mr. McLean, we can, if the deputy can tell me who's the next case. Medical, we are going to go into a breakout with Attorney Vigiletti. All right?
Sure.
I have
Next,
private
how you doing?
counsel,
We're gonna
Mr. Douglas. Who's your client?
She's asking first.
Sorry, I was trying to unmute. Judge Law, good to see you. Brandon Evans in position 6,
Okay.
22 CR 006601J.
All right. I just wanted to make sure the deputy knows that we are waiting for you, we are holding for your client, but I'm so sorry.
I'm sorry. He's on the way up to Fort North to get evidence as we speak.
Okay, thank you, Deputy, appreciate it. And Mr. McLean, I do apologize, you were trying to tell me who's your next client.
Well, I was about to interject that number 17 on our calendar, while someone is calling Miss McLeod, I believe that 17 was also hers, if I remember that correctly. We had two McGee's, and the one without the H in McGee was her client, if I recall correctly. I could be wrong.
Okay. And do we have one of your clients ready in courtroom 2?
Mr. Singleton is a probation revocation, Your Honor. That's ready. Is this
All right, let's address that, please.
He's here 5 and 6 on probation calendar.
All right. Officer Barnes?
Sorry, Your Honor, I was trying to figure out why I wasn't
Not a problem.
online. And what
Officer,
position is this?
this is position 5 and 6, Lorraine Singleton.
Gotcha. All right.
Officer Barnes, may I place you under oath? Do
Sure.
you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. We have Lorraine Singleton and the courtroom 2. Mr. Singleton, you have a probation revocation case 23 CR 005093F in which you were convicted of battery. Your probation revocation case is 24 PV 464. Officer Barnes, if you would please tell us what was his disposition and why you're seeking a revocation and what's the recommendation?
Sure. Thank you, Your Honor. This case was before Judge Richardson on August 31st of 2023. He was sentenced to 12 months of probation, report and pay supervision fees for the offense of battery. He is never reported to probation, Your Honor. He was ordered to complete the domestic violence class, as well as the drug and alcohol evaluation. Anger management course and the drug and alcohol evaluation.
Okay.
At this time, Your Honor, like I said, he never reported to probation. 259 days remaining on this case. Probation respectfully asks that probation be continued.
Mr. McLean?
Your Honor, my client had a substantial misunderstanding of which party should move to contact the other first. He thought somebody was going to contact him, and so he did not initiate. He is, I've talked to him in the jail yesterday. He is quite bright. Despite this misunderstanding, there won't be one in the future of that nature.
Mr. Lorraine Singleton, this is going to be marked as a probation violation on your calendar, on your record. You are going to be released and continued on probation. You will report to probation on Monday. Today is Thursday. You will report to probation on Monday at 132 Mitchell Street before 3 p.m. I want to be absolutely clear with you. The responsibility to report to probation is completely yours. You are the one who reaches out to probation, who contacts probation, tell them that you are alive and well and that you're not in trouble. You are to report in person on Monday, and you report every month. within 30 days from today, in other words, by your second probation visit, you must be enrolled in a anger management class, and you will complete 12 anger management classes. Do you understand?
Yes, Your Honor.
You have to complete 12 anger management classes. Within 30 days from your release, you will enroll and complete an alcohol and drug evaluation and submit yourself to any treatment that's required. You can go to any hospital or healthcare provider. Grady Hospital also provides these evaluations. And you must show proof that you've got an appointment date within the next 30 days by your second probation visit. Do you understand?
Yes, Your Honor.
You are to be up to date with your probation fees and any surcharges that you incur as you report to probation every month for the rest of the 259 days. Thank you. All right. Is Ms. Vigiletti signed on? Ms. Vigiletti? Olivia, is that your is Olivia Ms. Vigiletti's panel? Ms. Vigiletti, have you had a chance to sign on?
Yes, Judge, and in medical here is position 28, Haji Sissoko. We are ready to move forward with the plea as negotiated this morning.
All right. This is State versus Haji Sissoko, who is case 17 CR 0201948. Mr. Sissoko is located at the medical Zoom panel. Mr. Sissoko, my name is Judge Lal. I'd like to remind you that you have a right to remain silent about the facts of the case. Any statements that you make can and will be used against you in the treatment of your case. You have a right to an attorney, and representing you this morning is Ms. Olivia Vigiletti. You was accused of speeding 19 to 23 miles over the posted speed limit, operating a vehicle with no driver's license, and failure to maintain lane from November 25th, 2015. You have a second case, 17 CR 0259418. And this is also from, is this no, I think that's a duplicate.
Yes, there are duplicate cases open. It is the same incident.
Are they under different case numbers?
They are, and the state has recommended null processing one of those completely.
All right.
Yes, Your Honor.
So which one are you going to null process, Mr. Rhodes, 28 or 29?
Position number 29 will null process that upon the plea of position number 20.
All right. So this is the one and only case against you, Mr. Sissoko. I understand, and we understand you're going to enter into a negotiated plea. So may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Yes or no?
Yes.
Thank you. All right. Mr. Rhodes, what's the recommendation for these three traffic matters?
Thank you, Your Honor. As it relates to position number 28 on count 1 speeding, the state's recommendation is 12 months to serve 20 days. We show that he has credit for 10 days already. So if given 2 for 1, he would have completed the 20 days, and that the balance be served on probation. The probation can terminate upon completion of the sole condition that he pays a fine for $450. So upon paying that fine, the probation will terminate.
Okay.
It relates to counts 2. We're asking for 12 months probation to run concurrent with count 1 with the same condition that probation terminates. upon paying the $450 fine in count 1. And as it relates to count 3, 12 months probation to run concurrent with counts 1 and 2, with the same condition that the probation will terminate upon paying the $450 fine in count 1. Thank you, Your Honor.
Thank you. Ms. Vigiletti, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
We do for the first purposes of the plea, and yes, this is what Mr. Sissoko and I talked about. On probation, until you pay that $450 fine, then it terminates.
Okay. Mr. Sissoko, have you consumed any medicine or alcohol?
No,
And have you understood what's going on in your case?
yes,
And are you satisfied with your attorney?
yes,
And has she explained to you that if you decide to plead guilty to these charges, you will have to give up your constitutional right to a trial in front of a judge or a jury? You will not be able to go back to court, confront your accuser, challenge the evidence brought against you, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
yes,
How do you plead to speeding 19 to 23 miles over the posted speed limit, no driver's license, and failure to maintain insurance?
yes,
How do you plead? Guilty or not guilty?
guilty,
Your sentence for the speeding is 12 months to serve 20 days, credit for time served 10 days. You'll be on probation to pay off a $450 fine. Once
Yeah.
you have paid off the $450 fine, plus your probation fees and any surcharges, then your probation will terminate. This will, for counts 2 and 3, it will be the same sentence, 12 months probation, concurrent to count 1. All right? So the
yes,
sooner you pay off the $450, it will be less expensive for you.
okay,
You report to probation on Monday before 3 p.m. at 132 Mitchell Street, downtown Atlanta. Okay?
well, Monday, I have to go dialysis, Monday, Wednesday, Friday,
All right. Then you report to probation on Tuesday before 3 p.m.
2 or 3 p.m., okay,
April 2nd, 2024, before 3 p.m.
okay,
Thank you.
thank you.
Thank you.
Next, Your Honor, is going to be position number 30, Mr. Edwin Slater on the SAP calendar.
Thank you, sir. Edwin Slater is accused of criminal trespass from March 13th, 2024. Mr. Slater, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. Ms. Vigiletti, how are we proceeding?
Yes, Judge, this is another instance where I sent a counteroffer yesterday that does just request a slight change in the, a slight deviation from the recommendation, the solicitor sent yesterday.
Mr. Rhodes, have you received the counter?
Yes, Your Honor.
You could just summarize it. Okay.
Yeah, if she could summarize what that is, if it's slight, then I'm sure I probably won't have an issue with the judge.
Sure. So the recommendation right now for criminal trespass is to, it's time served on the jail time, serving 30 days, credit for time served 15 days, stay away from 3535 Peachtree Road, which is Target. And as of right now, the recommendation says, balance probated, 12 months probation. And I'm just requesting, as long as he's willing to stay away from Target, could it be a suspended balance so that, Mr. Slater, since there's no requirements of probation besides that stay away, could we suspend the probation balance?
I think that's totally reasonable.
So we suspend it once completion. Okay. All right. Mr. Slater, may I place you under oath for purposes of the plea? Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Your Honor.
I repeat.
Yes, ma'am.
Thank you. Mr. Rhodes, you need to tell me again, what was that? 12 months to serve how many days?
30 days.
Credit for time served?
Yes, ma'am, which is 15 days already.
All right. And what conditions were there?
Just to stay away from the Target, 3535 Peachtree Road, Northeast, Atlanta, Georgia.
Okay, and the balance is suspended.
Yes, ma'am.
Okay. Ms. Vigiletti, do you stipulate to the factual basis, venue, and ID?
We do for the purposes of the plea.
Mr. Slater, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you freely and willingly entering this plea, or is someone forcing you to take this plea?
Freely and willing.
Are you satisfied with your attorney?
Yes, ma'am.
If you decide to enter a guilty plea, you would have to make sure you stay away from the Target store in question. Are you prepared to do that?
Yes, ma'am.
And most of these Target stores already have your picture. And if you enter another Target store, they may ask you to leave. Are you prepared to do that?
Yes, ma'am.
All right. So there is a chance that you may have to stay away from all Target stores. Do you understand?
Yes, ma'am.
If you decide to plead guilty, you would have to give up your constitutional right to a trial. You will not be able to confront your accuser, challenge the evidence brought against you, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to do that?
Yes, ma'am.
All right. How do you plead to one count of criminal trespass?
Guilty, ma'am.
Your sentence is 12 months to serve 30 days, credit for time served 15 days, balance suspended. You're not to return to the Target store at the Peachtree Road location. And like I said, most likely you'll be banned from all other Target stores. So please do not risk by going into any of them.
Yes, ma'am.
Thank you.
Thank you, Judge.
Next case, please. Jail court iPhone, who do we have, please?
We have Mr. Evans, position 6 and 7 with the private attorney.
Okay. This is State versus Brendan Evans, case number 22 CR 6601J. Mr. Evans, my name is Judge Lowell. I'd like to remind you, please stand up straight.
Yes, ma'am.
I'd like to remind you that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you this morning is Mr. Chuck Douglas, who is appearing via iPhone. Do you see him on your screen?
Yes, ma'am.
All right. Mr. Evans, you've got a second case, on the first case, 22 CR 6601J. You are accused of battery, family violence, and battery against a female who is pregnant from September 2nd, 2021. With regards to your second case, 24 CR 514J, you are accused of driving, fleeing, or attempting to elude a police officer from May 14th, 2023. Mr. Douglas, are you still with us? Have we lost Mr. Douglas's connection?
I do believe so.
Signing back on now, Your Honor.
Okay. All right, Mr. Douglas, if you please unmute. All right. Your client has been advised of the two cases that are pending against him. How are we moving forward?
So there was another attorney with my office, Attorney Monique Milner, who was the lead counsel on this case. And she recently left our firm for the DeKalb DA's office. I messaged Attorney Pierre Thomas with the notes that I have from her with regard to resolution of the first case, position 6. And I'm not sure what his position is on that negotiation, but that's what I have. That's all I have. And so if for whatever reason we can't move forward with that recommendation, I would ask for some additional time for me to speak with Attorney Pierre Thomas because I'm positive we can resolve it with a plea. I think we're both kind of coming in the ninth inning on this one.
All right, Mr. Pierre Thomas, first of all, I really appreciate Mr. Douglas giving me any credit for understanding baseball terminology. But the other thing is, do you have a response to his email?
I have a response. I think that we're a bit off because I think that his understanding is maybe time served. And so if we can go into a breakout room to further pretrial while you move forward with, I guess, the latter end of the calendar that Deputy Rhodes can assist with, then I think we may be able to come to a resolution. My bigger concern is that we are here for two cases. And so are
Okay.
we able to find a resolution on the second case, or is there an understanding on the second case?
I'm going to put the both of you into a breakout room, and Mr. Pierre Thomas will go into a breakout room with Attorney Douglas. Ms. Champion, if you could please facilitate that. Gentlemen, you will receive a message on your screen to join the breakout session. Deputy at Jail Court iPhone, if you please mute until his attorney's available, or we can take another case up there. All right. Ms. McLeod, good morning.
Good morning, Your Honor. I apologize that I was not here earlier, but I was called in for a jail jury trial. It turns
Understood.
out that it did not go forward, so I am now available.
Okay, I believe you have two cases, a McGee and Miss Singleton?
Miss Collins.
Miss Collins.
Olivia
From
Collins.
probation revocation. I don't know if ACDC is, they had stepped off Zoom, but
Yes, I called and I spoke with Officer Milton, Your Honor, and she said she's going to come back in shortly.
Okay, and in the meantime, you have a Ogaris McGee.
That is correct, Your Honor.
All right, I will let courtroom two, do you have anyone available at the present time for Miss McLeod?
Who are
Ogaris
you?
McGee, position 17.
Yes, I have Mr. McGee here.
All right.
Your Honor, last week when we had spoken about Mr. McGee in a breakout room, and I do have some updates.
Do you need to be in a breakout room for that?
Yes, Your Honor, there are some MH issues.
All right. Ms. Champion, if you could place me in a breakout with Attorney Lamar Rhodes, Ms. McLeod, and myself. Oh, before we do that, I'm so sorry. Before you put us in a breakout, do not go into the breakout. Let's address Ms. Collins at Fulton ACDC. That's the only case that's holding them at ACDC. Officer Barnes, are you present? Excellent. Ms. Jaquavia Collins has got a probation revocation case, 20 COV 156, in which she was convicted of battery. And she's got a probation revocation case, 24 PV 461. Ms. Collins, you've been advised of your right to remain silent, and your attorney, Ms. McLeod, is now available. Officer Barnes, you've already been sworn. What is her disposition and what's the recommendation?
Your Honor, this case was before Judge Dixon on October the 21st of 2022. She was sentenced to complete anger management courses, 40 hours of community service, and to report and pay supervision fees. To our records, probation warrant was issued on June 6th of 2016 for failure to report on absconding supervision. The failure to report date was November the 17th, 2022, January the 24th of 2023, and April the 14th of 2023. Your Honor, we do not have proof that Ms. Collins has completed any of the community service hours, nor has she enrolled into the anger management course. At this time, Your Honor, there's 115 days remaining on this particular case. Probation will respectfully ask that probation be continued on probation, Your Honor.
And Ms. McLeod, do you accept that recommendation, or does
I do. I do, Your Honor. I think there's sufficient time for Ms. Collins to be able to complete the requirements that she was ordered to complete, Your Honor.
All right. Ms. Collins, I will accept the the probation officer's recommendation and continue you on probation. This will be recorded as a probation violation on your record. Please understand that you have a limited time to complete the conditions of your sentence. Do you understand, Ms. Collins?
I understand.
You will report to probation on Monday, April 1st before 3 p.m. And after that, you will report every month. You will complete at least 10 hours of community service within 30 days, and you will complete 10 hours every month thereafter, a minimum of 10 hours. You will also enroll in an anger management class and finish 8 anger management classes. You must show proof of enrollment by your second probation visit. In other words, you must enroll within the next 30 days and start your anger management classes show proof of enrollment and start your management classes at least 30 days later. And you must attend each and every weekly class consecutively with no breaks. You will continue to report to probation and keep up to date with your probation fees. Failure to do so will result in another revocation, in which time you can complete the rest of your days at the Fulton County Jail. Thank you.
Thank you, Your Honor.
All right, Deputy Milton, thank you so much. Before we go into a breakout, Mr. Pierre Thomas and Mr. Douglas, did you have an announcement?
Yes, the announcement would be we would be requesting a 1 week reset to handle both cases. It is a global offer. And
All right.
so I do believe the council needs some additional time.
The cases are going to be reset to April 4th at 9 a.m. That's for positions 6 and 7.
Thank you, Your Honor.
All right, thank you, gentlemen. All
May I be
right.
excused?
Yes, Mr. Douglas, have a good day. Thank you. Okay, I will be right back. I need to attend to one breakout session and then I'll be right back.
And Your Honor, now that Mr. Thomas is back, the breakout, position number 18 is his case.
18? Oh, okay, understood. In that case, Mr. Pierre Thomas, you'll be joining us in a breakout with Ms. McLeod for position number 18, O'Garis McGee.
Perfect.
I mean, let me put these people in the breakout. 1 minute. Jessica.
Ms. Champion?
Cloud. Okay, I'm ready.
Man, Tamika been doing this since 2019. I remember she went upstairs after, what's her name?
Yeah, because it was right before COVID.
Right. So today she had a jury trial.
A jail jury.
Jail not.
Like I know
So
Miss
they-
McLeod was in the jail jury this morning.
Then that's probably it. So they found a person guilty.
Miss Champion, you're not on mute.
All right, we are back. Mr. McGee, you are going to be granted a $2,500 signature bond through pretrial services, which means you can be released without having to pay for your bond, but you still do have an active case. You will be able to stay with your mother. You are not to have any violent contact with your mom, no physical altercations, and no verbal altercations. You're also to have no contact with Olan McGee. You're to stay away from Olan McGee and not speak with him in any way, form, or manner. You're not to possess any weapons or firearms, not consume any alcohol, and no illegal drugs. You're to continue with your treatment and make sure that you comply with all treatment and medication. Understood? You will report to pretrial services once a month. Ms. McLeod, could you please submit the proposed bond order as well as your waiver of arraignment?
I will do that, Your Honor.
And
And Your Honor, there is another case that I have, which is, I was asked last night whether or not I could do it, and I had told Mr. Jordan that if I was available, I would do it. Apparently, it's a conflict. The gentleman's name is Mr. Hosch, Hosch.
All right. I was just going to say, make sure you file the waiver of arraignment for Mr. McGee to Miss Grace, as well as the proposed bond order.
I will do that, Your Honor.
Thank you.
Your Honor, what was the amount again for Mr. McGee?
$2,500 signature bond through pretrial services.
Thank you.
No
Level
violent contact. Yeah, level 1. In person, not email.
Okay, thank you.
Right, thank you. And jail court iPhone, is that Mr. Hodge?
Yes, Your Honor.
All right. This is position 10 and 11. Ms. McLeod, would you need an opportunity to speak with him?
Yes, Your Honor, and I also would like to know what the state's offer is, if there is one.
All right, Mr. Quamarius Hodge, first of all, please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your legal representative is Miss Attorney Maureen McLeod. You're going to have a private session to speak with her, and he's got a bench warrant, 24 FTA 316 from January 4th, 2024. He's charged with possession of a pistol or revolver by a person under the age of 18 from October 18th, 2022. Mr. Pierre Thomas, if you could put the plea offer in the chat to Ms. McLeod. And Ms. McLeod, as soon as you receive that, we will put you and jail court iPhone into a breakout session. Right?
I have received it, Your Honor.
You have received it? Excellent. Okay.
Yes, Your Honor.
Ms. Champion, if you could place jail court iPhone and Maureen McLeod in a breakout session, please. Courtroom 2, who do we have, please?
Your Honor, this is going to be Mr. Joseph Daniels, position number 3 on the SAP calendar.
Thank you. State versus Daniels, Joseph Daniels, case number 24 CR 1219D. Mr. Daniels is charged or accused of willful obstruction of a law enforcement officer and a driving while license suspended or revoked. And this would be from March 14th, 2024. Mr. Daniels, you've been advised of your right to remain silent. Your attorney is Mr. McLean. Mr. McLean, how are we moving forward, please?
Your Honor, my client is pleading not guilty. He has a bond request.
All right. And will you be filing a waiver of arraignment, or would you like me to arraign the case?
I can do the waiver of arraignment in writing later today.
All right. With regards to Mr. Daniels, he's got a $1,000 bond that was set at initial appearance.
Your Honor, I believe it may be a surety bond. He's requesting,
It is?
and he's requesting the court to convert that to a signature bond. He, if I may launch in, he's been a line cook at a local restaurant for several years. Also for 6 years, he has had employment as a security person, a security guard. That is not 40 hours a week exactly. It's for the job. Your Honor, he was hit by a semi-tractor trailer and had neck surgery in 2019. That was about 5 years ago. He's had quite a few medical problems since then related to that serious injury. He graduated from or went to Southside High School, which is now it's Maynard Jackson High School. But Southside High School is pretty near downtown, and that's near Grant Park. Your Honor, basically the gist of the bond request to change it to a signature bond would be looking at partly looking at this, not just his background, but the seriousness of his charges. He will deal with these in court. He won't miss court, but it is one count of the license being bad and one count of too much delay and too much talking at the side of the road.
He does have a Clayton County hold, and I think that's still pending unless pretrial can correct me. Ms. Tyson, this is Joseph Daniels.
Aaron, that is correct. He does have a hold for Clayton County.
All right, and he's got a 2017 prior driver's while license conviction for driving while license suspended or revoked. Mr. Thomas, any comment?
On that regard, Your Honor, let me mention that the Clayton County matter apparently is a mistake because he hasn't been to Clayton County in forever. And that is based on something that is a Joseph Daniels, apparently, more recent that he's set foot in that county, so it can't be him.
The warrant is from 2020.
Yeah, he says he hasn't been in Clayton County in 10 years, so
That's come out in Clayton County.
common name.
Well, he'll have to go to Clayton County and clear that up. But unfortunately, he will have to be released to the hold only, so they would have to come pick him up.
Right.
All right, Mr. Pierre Thomas, again, any comment?
Yeah, given the nature of the charges and the idea that he has that hold, the state does not object to a release to the hold only in this matter.
Okay. On the willful obstructions, 1,000. On the driving while license suspended, it's 1,000. That's a $2,000 signature bond through the jail with a release to the hold only in Clayton County. Condition to the bond remains the same. Absolutely no driving unless he's got a valid reinstated license, adequate insurance, and proper registration for the vehicle that he operates.
Absolutely. Thank you, Your Honor.
If he gets pulled over again for the same offense, just remember to bring $2,000 with him when he comes back to jail.
Well, we'll have to stop by the bank first, but that's not going to happen. Thank you.
I like to see that happen if the officer allows it. Okay, thank you, sir.
Excuse me, Judge, is that through the jail?
Yes, ma'am.
Thank
2,000, 1,000 on each count,
you.
signature bond for the jail. Next case, please, in courtroom 2.
Next, Your Honor, it's going to be position number 1, Mr. Denzel Bentley.
Mhm.
If you don't want me to sit next to you, that's fine. I'm not your attorney. That is correct. He is pro se, I believe, Your Honor. We had no interview. He did not wish to talk.
That's perfectly fine. Thank you.
Sure.
This is State versus Denzel Bentley, case number 24 CR 1189Y. Mr. Bentley has been accused of simple battery family violence from October 9th, 2023. Mr. Bentley, you've been advised of your right to remain silent. Anything you say about the facts of your case during this recorded and live stream proceeding, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. Currently, the Public Defender's Office is availing themselves and providing their professional services to assist you. However, if you choose to waive your right to counsel and represent yourself, please do understand that the court will expect you to understand the case law and criminal procedures as they apply to the facts of your case. Any legal decisions that you make, you will be responsible for the impact that it would have upon your particular case. Would you like to still proceed with the assistance of the Public Defender's Office, or would you like to waive your right to counsel?
I'll proceed with the, but I'll proceed with them.
I can't understand what you're saying. Could you please sit up
I'll
straight?
proceed with them.
You'll proceed with what?
With the, public defender's office.
All right, please put your mask back on. Mr. McLean, who will be interviewing him? Would that be you or Miss Vigiletti?
Yes, Your Honor, I would have to start off by conveying an offer and getting, a name and address and phone number and begin an interview. We haven't had.
All right.
If we could put this to the end of the calendar today, I'll be able to address.
I'll just go to Miss Vigiletti. How long is it gonna take?
We'll talk right now.
Okay, yeah.
All right, so you're going to be, next case, please.
Your Honor, we're gonna go to position 13 and 14 on the SAP, and this is gonna be King Jones.
King Eugene Jones is accused of simple battery, family violence, and he's got a bench warrant as well. The bench warrant is 24 FTA 309. The simple battery, family violence is 23 CR 4962J from October 4th, 2021. Mr. Jones, you've been advised of your right to remain silent, and your counsel is Ms. Vigiletti. How are we proceeding, Ms. Vigiletti?
Yes, Judge, I did send a counteroffer on behalf of Mr. Jones, yesterday afternoon. And would just waiting to hear back on that.
The state has reviewed the counteroffer and has accepted the modified terms, Your Honor.
All right. Mr. Jones, if you please raise your right hand, I'll place you under oath for purposes of the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. And Mr. Pierre Thomas, what are the terms?
One moment, Your Honor. Your Honor, the terms of this plea is that, one moment. Is that the defendant is to serve 12 months on probation, to serve 48 days in custody. Credit for the 24 days that he's already served in custody. Looks like he was originally booked in on October 4th, 2021, and then rearrested on November 17th, 2023, released on November 30th, 2023, and then rearrested on March 20th, 2024. It's for the balance to be probated. The state has chosen to do away with the Family Violence Intervention Program requirement as part of the counteroffer. However, we would like for him to do 8 weeks of anger management, for him to have no further contact with Kyra Burton, for him to stay away from 6425 Oakley Road, Union City, and for him to do 40 hours of community service and to have no firearms. Unfortunately, our office was not able to get in contact with Ms. Burton, so if we could sound for Kyra, K-Y-R-A, Burton, in accordance with Marcy's law, that'd be greatly appreciated, and if we can get the defense to stipulate to venue, factual bases, and ID. But there's nothing further to add from the state at this time.
Kyra Burton? I don't see anyone by that name. All right. Ms. Vigiletti, do you stipulate?
We do, and if I may, Judge, Mr. Jones had a quick question. I just want to make sure we're 100% on the same page before we proceed.
Was that a correct question directed to you or to Mr.
To
Thomas?
me, yes, I just.
Go ahead.
Okay, thank you. Okay, we are prepared to proceed. Thank you, Judge.
All right. Mr. Jones, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
And are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
If you decide to plead guilty to this charge, you would have to give up your constitutional right to a trial before a judge or a jury. You will not be able to confront your accuser, challenge the evidence brought against you, present any defenses, arguments, and mitigating factors if you choose to do so, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of simple battery, family violence?
Guilty, Your Honor.
Your sentence is going to be 12 months to serve 48 days, credit for time served 24 days. Your time at the jail is concluded, and if you have no other cases holding you, you should be released within 24 hours. You will report to probation next Monday, April 1st, before 3 p.m. And the probation office is located at 132 Mitchell Street in downtown Atlanta. Within 60 days of being released, you will enroll in an anger management program, and you will complete these 8 classes consecutively with no breaks. You're also to complete 40 hours of community service at any nonprofit agency that's not a church and not a school. You will begin your probation with completing at least 5 hours per month. Do you understand?
Yes, ma'am.
Minimum of 5 hours. You must report every month to probation. At all times, you're to have no contact with Kyra Burke. You're to stay 200 yards away from her and not communicate with her in any way, form, or manner. You're also to stay away from 6425 Valley Road in Union City.
Judge, I am so sorry. Miss Burton is the mother of Mr. Jones' child. Is it possible that they can set up a third party to have visitation for his
Even
4-year-old?
Even better, while he's on probation, he will apply and file a legitimation action in the appropriate superior court and get a court order establishing visitation, custody, and child support for the child he shares with Ms. Burton.
Okay, thank you, Judge.
And Your Honor, if I could announce that the state intends to null proposition 14 in connection with the plea on position 13.
All right. And his bench warrant is null prost. Thank you. Ms. McLeod, are you ready to address Mr. Hodge?
I am, Your Honor.
All right. Mr. Hodge has already been advised of his charge on position 11, possession of a pistol by an underage person. And how would we be proceeding?
It's going to be a non-negotiated plea, Your Honor.
All right. Mr. Hodge, you have been advised of your rights. Please, may I place you under oath for purposes of a plea if we move forward? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. This is going to be a non-negotiated plea. So Mr. Pierre Thomas, the prosecutor, no, was it Mr. Pierre? No, it was Mr.
Yeah.
Rhodes, wasn't it?
It's
Oh,
me. It's
all right.
me, Your Honor.
So Mr. Pierre Thomas is going to give me a recommendation of what your sentence should be if you decide to plead guilty. And Ms. McLeod will give me an alternative recommendation. I will let you know which option I will select before we move forward. Mr. Pierre Thomas?
Your Honor, if we could have the luxury of hearing from Madam pretrial, as I believe that the recommendation is contingent upon his history, Your Honor.
Ms. Tyson, if you could give me a record of his adult criminal history record, if any.
Yes, Your Honor. He has 7 arrest cycles beginning in 2022. Looks like he has a possible pending misdemeanor willful obstruction. That arrest date was November 28th of 2022 by Georgia State Patrol. He has a misdemeanor conviction out of Cobb County for theft of services, theft by shoplifting. That disposition date is October of 2023, and he has 1 failure to appear, which is the one that's listed on the calendar. And it looks like he does have a hold out of, it's like Cobb County for a probation violation. That warrant was signed January 10th of 2024. One moment. Nothing to add, Your Honor.
Thank you.
And Your Honor, we have that he had an arrest for an entering auto. Looks like the arrest was on November 5th, 2023. And then also prior to picking up this charge, which is the possession of a pistol or revolver by a person under the age of 18, he had an arrest for the exact same charge prior to that, looks like, which was an adult arrest. Looks like on March 19, 2022, Your Honor. The recommendation from the state as it relates to this case is for the defendant to serve 12 months on probation, for him to serve 210 days in custody, credit for the 32 days that he's already served, for the balance to be probated, and for him to have no firearms while on probation, Your Honor.
Ms.
Your Honor,
McLeod?
would you like that case number for that open case? I apologize. I should have given that one to you. Would you like
Yes,
it?
go ahead.
24 SC 001097.
Thank you. I was just going to look it up, but thank you very much. Appreciate it. Ms. McLeod?
Yes, Your Honor. I am asking for time served with probation. I am asking that he be released so he can go to take care of his probation violation in Cobb County, Your Honor. My client is 19 years old. He tells me that he is expecting a child in the next couple of weeks. He tells me that he was not raised by his parents. He was raised, I believe, he and his older brother by his great grandmother, who is now in a nursing home. So, you know, he's sort of not had some of the advantages that he should have had. He really doesn't have any convictions other than that conviction for shoplifting in Cobb County, Your Honor. And he has spent 32 days already in jail. He does want to get out so that he can be around for the birth of his child, Your Honor. And he's okay with probation and with not having any firearms. So I would ask the court to consider less time just sitting in jail and release him so that he can go take care of his hold in Cobb County, and then he can be on probation in Fulton County. That's what we're asking.
The hold in Cobb County, that's also a felony case, isn't it?
I thought it was for the shoplifting, Your Honor.
Though that's in DeKalb, theft of services and theft of shoplifting in DeKalb.
I
From
thought it was
October 2023.
probation violation in Cobb County.
He's got a probation hold, and I thought it was a felony charge. Am I incorrect?
It's a misdemeanor charge out of Cobb County, the theft of services and the theft by shoplifting. That's out of Cobb.
And what about DeKalb? I think did I mishear? Was that a DeKalb?
I don't have anything in DeKalb. It looks
Okay,
like he has
cool.
that misdemeanor, that willful obstruction, but
No.
I don't have any information. That was
That's
from
why-
Georgia State Patrol. Mhm.
That's why I was out. Okay,
Yep,
sorry.
that was Georgia State Patrol. It's okay.
All right, so the Cobb County is theft of services and theft of shoplifting from October 2023. And November 5th, 2023, he got arrested for entering an auto. He's got a prior offense for possession of a pistol. And you want me to give him time served on a repeat offense involving a firearm?
No, Your Honor, I'm asking that he be
I'm
on
really, yeah,
probation.
tell me why am I letting this really troubled young man who's not been able to keep out of jail or not be able to stop reoffending to serve additional jail time?
Your Honor, he's going to be having a child, which
A lot of people have children, whether they're in jail or out of jail.
I understand, Your Honor.
Not something to write home about, but I'm still struggling with why should I dispense special favor for him?
Well, Your Honor, he doesn't have, other than the theft of services and the shoplifting, he doesn't have any convictions.
He has an open felony case while he was on probation. Immediately after he had an offense in Cobb County. This is not someone who's had time to think about rehabilitating. He's got a major event in his life, and you're asking me to give him a special favor. No, he's not getting it. I think the offer by the state is extremely reasonable, given his criminal history record, his pending open cases, the fact that he is a child, mazel tov. But right now, he needs to understand that he needs to fix his life by paying his debt to society. So, in that light, would he like to plead not guilty and move forward with a trial? Because,
Yes, Your Honor.
all right. Will you be filing a waiver of arraignment?
I will file a waiver for arraignment for him.
I think that would be the best.
Do you have a question, Mr. Hodge?
Yes.
What is that?
I'll just plead guilty and do the time that she said I gotta do.
You now want to accept the state's offer, are you sure?
Yeah, I accept. But I accept the offer because this what she said. I mean, I was just trying to, cause my baby going 2 weeks, so I was just trying to get out. You feel me? Cause I know my baby gonna change my life and jump my head. Like, you feel me? Like it ain't like I got out. It just me at the wrong place at the wrong time. Me not being the person that tell on people. That's the reason why I got me in the situation that I'm in. That's why I just gotta get. That's why I had a baby so I could get out and change my surroundings and change my life. But I just take the time. I just take the offer that the judge and the state are giving me because it's the only. That's the only offer I got.
It appears that he wants to accept the state's offer, Your Honor.
All right. Ms. McLeod, do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor, I do.
Mr. Hodge, have you consumed any medicine or alcohol recently?
No.
And have you understood everything that's been going on so far?
Yes.
And you understand that the state is asking for you to serve 210 days less than 32 days.
Mm-hmm. Yes, Your Honor.
All right. Which means you have about 73 more days to serve at the Fulton County Jail. Do you understand that?
It ain't 2 for 1?
With 2 for 1, you have 73 more days to serve at the jail.
All right.
Are you still willing to move forward with the plea? Mr. Harsh?
Yeah.
Are you still willing to move forward with the plea?
Yeah.
Are you satisfied with your legal services?
Yes.
Are you entering this plea freely, willingly, and knowingly, or are you doing it just to get out of jail?
You said for both of them. I'm really doing it for my to get out of jail for my baby. Like I'm not trying to really be in here a long time. I'm doing it to get out of jail for my baby, and I'm doing it knowingly and knowing that I was wrong, really.
All right. If you decide to plead guilty, you would have to give up your constitutional right to a trial. You will not have the assistance of counsel to go back to court, to confront your accuser, to challenge this charge in a court of law before a judge or a jury, to be able to present any evidence of your defenses, your arguments, or any mitigating factors. And you would also have to give up your right to have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to one count of possession of a firearm by an individual under the age of 17 as occurred on October 18, 2022?
Yes, Your Honor.
How do you plead?
I plead guilty.
Your sentence is 12 months to serve 210 days, credit for time served 32 days. Based on my calculations, you have about 73 more days to serve at the Fulton County Jail. Once you are released, that will conclude your sentence. At all times, you're not to be in possession of a firearm. You do have a hold in Cobb County. So once you complete it with your sentence, Cobb County will have to come pick you up and address your probation matter in Cobb County. And then after that, you have an active case in Superior Court of Fulton County to deal with. Thank you.
Yeah.
Yes, Your Honor, I was thinking, he has already served 32 days. I don't know, my math is terrible. If they do 2 for 1, that would be like 64 or 66.
Maybe I miscalculated. That's why I've got 210 days. I gave him credit for 64 days, which gives me a remainder of 146. And if I divide that by 2, that's 73.
Okay. It's just my bad math, I guess.
It's remarkable how many times we admit that on Zoom, on live stream. So
I am terrible at math. That's why I went to law
Oh.
school. So I'm not even going
please
to
don't
try.
repeat. That goes out to the whole world. All right.
Excuse
Okay.
me, Judge, is this gonna be probated or suspended?
It's the balance suspended.
Thank you.
All right. Thank you.
Thank you, Your Honor. I will have the plea form prepared and submitted to, is it Ms. Grace who's on today? Yes, Ms.
Today's
Grace.
Ms. Grace. Thank you very much. Okay.
Your Honor, that concludes my business before the court. May I be excused?
Yes, Ms. McLeod, you have a good day. Thank you.
Thank you.
Jail court iPhone, who do we have, please?
We have position number 35, Mr. Cedric Williams.
Cedric Kennard Williams is accused of theft by receiving stolen property, a misdemeanor from January 30th, 2024. Mr. Williams, my name is Judge Law. I'd like to remind you that you have the right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you this morning is going to be Mr. Michael McLean. Mr. McLean, how are we proceeding with your client?
Your Honor, he is not guilty. He will vigorously defend this in court. It has to do with a pawned item, and the fingerprint is not going to be his. Somebody did steal his ID, however. Your Honor, we would like to ask to have a signature bond if possible on this. It is a property crime. Of course, that is a serious crime, but he is vigorously contesting his guilt. We would like to ask the court to consider allowing him to address this from the standpoint of freedom.
All right. Mr. McLean, first, will you be submitting a written waiver of arraignment?
Yes, Your Honor, I'd be glad to do that in writing later today.
He received a $3,000 good bond or surety bond from initial appearance with no contact with Christopher Strachan. And I guess to stay away from some location, 15th something at Piedmont Avenue. All right.
That's no doubt. That would be probably the pawn shop and the person who works there.
All right. Mr. Rhodes?
Yes, Your Honor, thank you so much. As it relates to position number 35 and Mr. Williams, the state has moved to, I don't know if I can be heard, but the state has moved to transfer this case to the DA's office. While you guys were handling cases, I've been informed that they have accepted it. And that is based on the defendant's criminal history of having more than 3 theft-related cases in his history. So therefore, upon the 4th, even though it is a misdemeanor, it can be transferred as a felony, Your Honor. And so the case has been transferred and accepted by the DA's office. I was trying to get the CP number from the DA's office. I'm still awaiting that. Once I get that, I will share it with the court. What I would say, I'm sorry, Your Honor?
I know, I said, okay.
So what I would say that now that this case is with the Superior Court, I don't know of our ability to address bond in it. However, if the court is inclined to address bond,
I haven't signed the transfer order, so I still have jurisdiction to address bond. You may proceed. Go ahead.
As it relates to the bond situation, Your Honor, we believe that the 3,000 good bond is reasonable. I am showing that the defendant has 18 cycles on his GCIC and also out-of-state history in the state of Alabama. In addition to that, I'm going to ask Ms. Tyson if she would read what she has as it relates to the defendant's criminal history.
All right. Mr. Rhodes and Mr. McLean, his pre-indictment case number is 24 PI 001972. It is now a felony case for theft by receiving stolen property. I don't know. Yeah, it's for the incident from January 30th, 2024. So Mr. Rhodes, if you will submit the transfer order to the litigation manager, Melissa Grace. In the meantime, I will amend the bond to a $3,000 signature bond through pretrial services level 2. Mr. McLean, you can submit the proposed bond order with the original conditions remain. Mr. Williams, your case for theft by receiving stolen property, the one involving the pawn shop, is now a felony case. So you will be reporting to the Superior Court of Fulton County with regards to that case. Do you understand? I'm
Yes.
amending your bond to a signature bond through pretrial. You will report to pretrial services twice a month in person. If you get arrested again for anything else, your signature bond will be converted to a cash bond or a surety bond. Do you understand, sir?
Yes.
Same other original conditions apply. Thank you.
Much appreciated. I think I was going to mention to him, I think Your Honor did say that. Level 2, Mr. Williams, means twice a month. I think he's gone. He's gone. They got it.
He got it. Thank you.
Thank
Next
you.
case, please. I can deputy. are
Next,
you
Your Honor,
ready?
Thank
we're
you,
gonna
Ms. Tyson.
position number 19, Mr. Jerry Miller, position 19.
All right. We're gonna hold on courtroom 2, position 19.
This is courtroom 2 with 19.
Oh, I see. Sorry. Okay. Sometimes the audio band shows up on both the Zoom panels, so I apologize. I sometimes can't tell who's making the announcement. But this one is Jeremy Miller, who is seated next to Miss Vigiletti. Would that be correct?
Yes, Judge.
All right. And his case is 24 CR 1196J, accused of criminal trespass from February 25th, 2024. How are we proceeding?
This is another instance where I did send a counter offer for just a very minor change, and I can just summarize it right now.
Please do.
Yes, so the state's offer, this is a criminal trespass case. Mr. Miller has a permanent ban from MARTA. It's a little bit of a misunderstanding. A DeKalb judge told him he had a ban from 3 specific locations of MARTA. Mr. Miller didn't realize that MARTA also has its own banning system. So, you know, the MARTA had given him a permanent ban. He was in compliance with the DeKalb judge's ban, didn't realize MARTA had its own ban. So he did trespass at MARTA. He does understand now that he has a permanent ban from all MARTA. The state is requesting 12 months of probation. That doesn't include any requirements other than staying away from MARTA. So I'm just requesting this morning possibly a suspended balance rather than a probated balance, as long as Mr. Miller stays away from MARTA.
And the state has previously reviewed the counteroffer and does accept, and will convert the balance probated offer to balance suspended.
All right. Mr. Miller, may I place you on oath for purposes of the plea? Mr. Miller, may I place you on oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do, Your Honor.
Thank you. Mr. Pierre Thomas, so this will be 12 months to serve how many days?
12 months to serve 32 days, credit for the 16 days that he's already served. It looks like he was booked in on 6/13/2024, I guess until today, for the balance to be suspended and for him to stay away from all MARTA properties officially.
Ms. Vigiletti, do you so stipulate?
We do for the purposes of the plea.
Mr. Miller, have you consumed any medicine or alcohol?
No.
And have you understood the proceedings so far?
Yes,
Are you satisfied with your legal services?
I am.
And has anybody explained to you that if you enter this guilty plea, you would have to give up your constitutional right to a trial, to be able to have the assistance of counsel, to confront your accuser in a court of law, to be able to present any defenses or arguments you may have, and have the state prove the charge against you beyond a reasonable doubt? Are you prepared to waive these rights?
Yes, yes.
How do you plead to one count of criminal trespass?
Not guilty.
You say guilty or not guilty?
Not guilty.
So if you want to take the plea, then you're pleading guilty, right? You did trespass.
Oh.
If you don't want to take it, you can plead not.
Okay.
So if you want to take the plea today, then you would plead guilty.
I am.
Because you acknowledge that you were did trespass.
Yes, yes, I trespass.
Okay, okay.
My apologies.
I'm sorry, Judge, that Mr. Miller was confused. Could you please?
Mr. Miller, are you pleading guilty to violating the law and trespassing on Marta property when you should not be doing so? Are you
Yes.
pleading guilty to that charge?
Yes, I am.
Your sentence is going to be 12 months to serve 32 days, credit for time served 16 days, balance suspended. If you have any questions, this is the time to ask, but let me be very clear with you. You cannot return to any bus station, train station, or any property that belongs to the Marta company. You cannot be on a train or a bus. You cannot be sitting under a bus stop. You cannot be at the train station using their parking lots, their bathrooms, their sidewalks. Absolutely stay away from all Marta property, whether it's in Fulton County, DeKalb County, Clayton County, wherever they happen to be. You have a permanent ban. They're going to lose their $2.50 every time they have an opportunity for you to use it. Do you understand?
I do.
All right. That would be a plea. Thank you. Jail court iPhone?
Okay, we have position number 31, Mr. Steve.
This is State versus Devontae Cantrell Steed, 24 CR 1212A. Mr. Steed, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your counsel is going to be Ms. Vigiletti. Ms. Vigiletti?
Yes, Judge, this is another instance where I sent a counter offer yesterday, just asking the state if they would consider a sentence of serving 30 days rather than 45.
Mr. Rhodes?
Yes, Your Honor. On this case, the state will consent. I did want to bring to Ms. Vigiletti's attention, though, that I'll consent because I think it's reasonable, not for the reasons you stated, because I don't think he's going to be transported to Richmond County based on the police. So I'll go ahead and consent on for other reasons. I do think it's reasonable.
Thank you. I'm sorry, I saw that hold in Richmond County and I didn't realize that he wouldn't be released there.
Yeah,
So
officers indicated that on their system, it indicated they're not going to extradite him, so they're not going. So that's not our problem.
All right. Jail court iPhone, maybe unmute, please. Mr. Steed, if you are moving forward with the plea hearing, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Do you so swear?
Yes, that's right.
Thank you. Mr. Rhodes, so what are the terms of the plea offer?
The terms of the plea offer as it relates to position number 31, Mr. Steed, is 12 months to serve 30 days. I show that he has been in custody already 15 days. So if he receives credit for time served, he would receive 2 for 1. The balance to be served on probation. We're asking that he undergo the Family Violence Intervention Program, which is a 24-week program, and that he completes 40 hours of community service. And that he has no further violent contact with Uniqua Arrington, who we've not been able to get in contact with, but we do understand that they share a child together, and that while on probation, that he has no firearms. And that's the state's recommendation, Your Honor.
All right. Ms. Vigiletti, does your client accept these terms, and do you stipulate the factual basis, venue, and ID?
We do for the purposes of the plea, and this is what Mr. Steed and I discussed. So Mr. Steed, you tell me if anything changed, but I think we're prepared to move forward with the plea as negotiated.
So Mr. Steed, are you willing to move forward?
Yes, ma'am.
Okay. Have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Ma'am.
I'm sorry, I can't hear you. Do you want to step a little closer?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
Has it been explained to you that if you plead guilty to this charge, that you would have to give up your constitutional right to a trial in front of a judge or a jury? You will not have the opportunity to have the assistance of counsel to go back to a court of law, to confront your accuser, challenge the evidence brought before you, have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights? Are you
Yes.
prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of simple battery family violence?
Yes, ma'am. Oh, yes.
Your sentence is going to be 12 months to serve 30 days, credit for time served 15 days. The remainder of the time you will be on probation. Once you're released from the jail, which should be within 24 hours, if you have no other holds, you will report to probation on Monday before 3 p.m. Today is Thursday. Once
Yes,
you're
ma'am.
on probation, you are to enroll in a domestic violence intervention program, and you shall enroll in this program within 30 days of being released. By your second probation visit, you must show proof that you have enrolled. You're also to complete 40 hours of voluntary community service, and you must begin by completing at least a minimum of 5 hours per month, every month. You are to have no violent contact with Aniqua Arrington, which means that you cannot have any future physical and or verbal altercations with Miss Arrington, and you're not allowed to own any firearms.
Yes.
Thank you.
Next, we can go to
Alex Williams.
And Your Honor, I wanted to make sure that you saw my request.
Okay, is it right now or can you wait a little?
Oh, it can wait, it can wait.
All right, thank you. I'm sorry. Is that the case with jail court iPhone or courtroom 2?
jail court.
Okay, thank you. We have, position number 34, Mr. Alex Williams.
Alex Williams is accused. Alex Williams, please raise your right hand. All right, just want to be sure. Thank you. Put your hand down, please. Alex Williams is accused of battery family violence from March 14th, 2024, case number 24 CR 1215C. Mr. Williams, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. How are you proceeding, Mr. McLean?
Negotiated plea, Your Honor.
All right. Mr. Williams, please raise your right hand. Do you swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am, I do.
Thank you. Mr. Rhodes, what is the plea offer?
Yes, Your Honor, as it relates to position number 34, the plea offer from the state is 12 months to serve 30 days, credit for time served for, credit for 15 days, which by my record reflects that would be 2 for 1, which would be 30 days, balance on probation, that he undergoes a family violence intervention program, which is a 24-week program, that he completes 40 hours of community service, the 501c3, that he has no further contact with April Parham, and that he stay away from 4120 Fulton Industrial Boulevard, which is the Budget Inn Suites, and that he is to have no firearms while on probation. And that's the state recommendation.
Mr. McLean?
Your Honor, that's correct. That is the offer we expected to hear. That is what I conveyed to him, and he wishes to accept that, Your Honor. He asked the court to accept his negotiated plea. He stipulates to 3 necessary elements: jurisdiction, that is state venue, and also factual basis and identification for the purposes of the plea today.
Thank you. Mr. Williams, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
I am.
And are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
If you decide to plead guilty, you would have to give up your right to a trial in front of a judge or a jury. You will not get the opportunity to go back to court with your attorney, to confront your accuser, challenge the evidence brought before you, present any arguments and defenses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
I am.
How do you plead to one count of battery, family violence?
Guilty.
Your sentence is 12 months to serve 30 days, credit for time served 15 days. If you have no other holds, you should be released within 24 hours. You will report to probation. You will report to Fulton County Probation on Monday. Today is Thursday, so make sure you report next Monday before 3 p.m. It's April 1st, 2024. While
Yes,
on
ma'am.
probation, you will complete a domestic violence program, and you must enroll in that program within 30 days of being released. I'm going to give you 60 days. You are to enroll in that program within 60 days of being released. So by your second probation visit, you must show proof of enrollment. You're also to complete 40 hours of voluntary community service with any nonprofit agency that's not a church and not a school. And you must complete at least 5 hours per month, beginning with the first 30 days. Do you understand?
Yes, ma'am.
And report at least 5 hours per month. You have to have no contact with April Parham, and you cannot return to the Budget Inn Hotel at 4120 Fulton Industrial Boulevard. At all times, you're not to be in possession and cannot own any firearms.
Understand.
Thank you.
Thank you.
All right.
Your Honor, next, can we go to position number 1 in courtroom 2, Mr. Bentley again?
Okay. Denzel Bentley is case 24 CR 1189Y. He has been advised of his right to remain silent, and he has elected to have appointed counsel, who is now Miss Olivia Vigiletti. Ms. Vigiletti, how are we proceeding?
Judge, this morning, if I could just request a 1 week reset on Mr. Bentley's case. The state is requesting 86 more days in jail, and Mr. Bentley does have a probation issue that will not be resolved till April 12th. And so that'll give me some time to get up to speed on this case.
Reset to April 4th, 2024, 9 a.m.
Thank you, Judge.
Jill, where are we going now? Courtroom 2 or jail court iPhone?
If we could go here, we have position number 18, Mr. William McGee.
18, okay. This is William McGee. The other McGee, all right. Case number 20.
This is McGee with an H.
McGee with an H, got it. 24 CR 1093C is the accusation number. Mr. William McGee, you are accused of simple battery family violence from March 6, 2024. Mr. McGee, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. Mr. McLean, how are we proceeding?
Not guilty and a bond request, Your Honor.
All right. Will you be submitting a waiver of arraignment?
Yes, I will.
All right. Mr. McGee, your attorney, Mr. McLean, will be submitting your not guilty plea to the court in writing, and your case is going to be further notice for trial. Presently, Mr. McGee was received I believe it was a surety bond.
Yes.
This was for $3,000 on March 8th, 2024. It was subsequently amended to a $1,500 good bond on March 16th, 2024, which
Your Honor allowed that last week.
correct. What has changed? in a span of 10 days?
Nothing, Your Honor, but there was discussion, nothing on that, but there was discussion that the state could perhaps get hold of the video, and we could, if not the video, at least the audio. This was the question where his mother has dementia. There was a leading question by the police
Oh,
officer
Mr.
investigating.
McLean, I'm familiar with the case.
Right.
I'm just trying to figure out, are you asking the state whether they're amenable to a change in the bond?
Well, I wondered if the state got hold of the video. That was the main thing we were trying to figure out, is if the video showed that the officer simply said, well, did he hit you, or did he mush you with his finger, or what did he do? And if she just said yes, if it was a leading question, it may make the state feel that it would be fair to consent to a signature bond. But we haven't seen the video. We don't investigate these cases at the state all-purpose level. The investigation is done at a different level.
Mr. Pierre Thomas?
Yeah, we've made note that we've attempted to get a hold of not only the video, but the 911 call and listen to that. We have not, to my knowledge, we don't have that in our possession. But I certainly can make the affirmative statement that we have not watched the video at this moment. And so the state's position is the same as it relates to bond.
All right, Mr. McLean?
Right.
Nothing changed.
As your honor recalls, he was simply saying that he takes care of his mom, and that it's very necessary for him to be home. He does of course appreciate the bond reduction last week. He doesn't have the money to make that.
I clearly recall Mr. McGee's version of events, and then I have the other version, which is on the warrant. So we have two dueling versions of this case, which can only be resolved through a trial. So the bond remains the same.
Right, and we just like to know, we haven't heard from Madam Pretrial, but we can see that he at least has 64 cycles.
I remember that too. I really don't need his recitation of his extensive criminal history record. Mr. McGee, I do see your hand is up. Please remember that you have a right to remain silent. Anything you choose to say in open court could open yourself up to incrimination, because your statements can be used against you.
Yes, ma'am. You want me? Okay, I just want to say this. There's actually another version, because the ticket, when the officer gave me a ticket, he wrote me a ticket, it's substantially different from the account of the event that you have on your desk. In other words, I need to know, where is the ticket that the officer wrote when they arrested me? They're totally not, it's another version.
Okay.
So somewhere between, what I'm saying is this, Your Honor, I don't believe that this officer was forthright when he wrote the warrant, that when he went to see the judge and got that warrant that's on your desk. There's another version, an officer's sworn testimony that's on that ticket. And they don't match.
Mr. McGee.
Yes, ma'am.
Mr. McGee, these
Yes.
contradictions in the assertions, whether it's in the officer's ticket or whether it's in the warrant. The warrant says that the accused allegedly caused physical harm to his mother, Edith Bergeron, with whom he lives, by open hand striking her in her forehead with his palm during. The ticket states, did mush meaning in quotation marks, his mother's face during a verbal agreement. You and I can agree or disagree, but right now there is probable cause that this victim was struck in the face.
All right. Well, Judge, no one's asked her. And then the other thing about it is this.
And that's all I'm going to address.
Well, one more thing, Your Honor. Why has no one, the whole incident was on 911, on a 911 call? If
Mr. McGee, there is a warrant. That concludes your case.
That officer stayed gone all night. I was in the hospital. He
Officer
stayed gone
Norris,
all night.
this case is concluded. He's going to keep
Yeah.
challenging this case. Thank you. You've received a bond modification that concludes the case. Thank you.
Well said.
Your Honor, we're gonna go back to courtroom 2. This is gonna be position number 39, David Wright.
39, okay. Mr. McLean, is that your client?
No, Your Honor.
Okay.
There you go.
All right, Ms. Vigiletti, you are seated next to David Wright, case number 22 CR 662E, accused of driving under the influence of alcohol less safe and driving while license suspended or revoked. Mr. Wright has been advised of his right to remain silent, and his counsel is Ms. Vigiletti. How would we like to move forward?
Yes, Judge, Mr. Wright was before this court on March 12th, where he pleaded not guilty. He has changed his mind. Here we are a couple of weeks later and would like to enter a plea. He did receive a slightly different plea offer on the 12th than the offer made this week. So I did reach out to the solicitors, but I know I've sent you all so many requests yesterday. Totally understandable if you haven't looked yet, but we are wondering if it's possible for Mr. Wright to enter the plea offered on March 12th, SAP.
Mr. Rhodes or Mr. Pierre Thomas?
Yes, Your Honor, that is, Mr. Rhodes. So I did get a chance to look at that one as well. And on that one, I thought that the offer, and I if you could tell me what that offer was on the 12th, I don't have the 12th calendar because I wasn't here on the 12th. I think maybe Deputy Falk was here, but.
Sure, yeah. Sure, I can read it to you. It's, and I can also send it to you in writing from Ms. Falk, but it was 12 months of probation.
Could you send it to Mr. Rhodes, please? And then I can take up the next case while
Mr.
y'all
Rhodes,
still
I did
flesh out the
attach it.
terms.
I attached it to the announcement, I attached it to the email where I sent counter offers.
I saw that you said that it was I didn't see the attachment. So if you resend,
Okay. I'll just send it again, no problem.
thank
All
you.
right. All right, we'll hold on Mr. Wright. Jail court iPhone, who do we have?
I'm sorry, we have position number 21, Mr. Neal, sorry.
With Neil.
What's that, Clifford Neal?
Yes, Your Honor.
Yes.
Okay. Mr. Clifford Neal is 24 CR 1071C, accused of battery, family violence, and battery against a female who's pregnant on February 2nd, 2024. Mr. Neal, you have a right to remain silent. Anything you choose to say about the case, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. Mr. McLean, how would your client like to proceed?
Your Honor, that's a not guilty in a bond request. I think at this time he has a $10,000 bond, if I'm correct.
All right. And Mr. McLean, will you be submitting a written waiver of arraignment for this case?
Yes, Your Honor.
All right. That case, position 21. Do apologize, Mike. So Mr. Neal did receive a bond, and this was on March 7th, 2024. It was 5,000 surety on each count and no contact with Sade Williams. Yes, Mr. McLean, what is the reason for a modification?
Your Honor, I've tried to get hold of some people to talk about the case. I've been unsuccessful in doing that, despite efforts. Your Honor, he is simply pointing to the allegations themselves, and he feels that his record does not justify that sort of bond based on these allegations. It is a matter of a dispute between his daughter and another person his daughter's age. And he got accused in the middle of it and feels that it really has more to do with other people than him. The niece, I believe, Sade Williams, I believe is his niece, but I believe his daughter was involved in that. I may be mistaken about the daughter, maybe it was his niece and a classmate of the niece. But at any rate, Your Honor, he does have a medical condition. He had a heart attack, and it was confirmed by EKG after the fact, about the time that he was arrested on this. He felt that he felt he wasn't fully participating very much in his first appearance because it was just a day or two after that. And so he would like to, at that point, that can be shown. I can get Grady records to show what day he was taken to Grady.
Was this a condition while he was at the jail or prior to that?
Right prior to that, like a day or two, he was feeling very poorly. And he was trying to pay attention the best he could. And he thinks he did poorly in the first appearance, presenting himself because of that.
Well, my case is not the only one holding him at the jail. He's got the Superior Court matter as well.
Right. That's true.
And he's got two foreign holds as well.
That is correct. Your Honor is correct on that.
Okay.
But this matter sort of stands alone as to what he's accused of. So we're looking at the allegations.
All right. Mr. Rhodes or Mr. Pierre Thomas, I'm not sure who's countering this.
Yes. You know, I don't know if I might have missed it. I don't know if I heard what the defense was asking for. I know they're asking for a bond modification. I just didn't hear what the bond modification numbers were.
Right. A signature bond would actually be his request. Yes.
Okay. All right, Your Honor. As it relates to position number 35 in the request for bond, we believe that the bond that this court has recently said is reasonable given the nature of the charges and
this is number 21, Clifford Neal.
Yeah, Clifford Neal.
Okay.
Yes. Position number 21, Clifford Neal. We believe that the bond that was set by this court previously was reasonable given the nature of the charges, battery, family violence, and then also battery against a female who is pregnant. In addition to that, Your Honor, I will point out that this defendant, in addition to the holds that the court has already pointed out, has a total of 35 cycles on his criminal history. His extensive interaction with law enforcement needs to go noted, Your Honor. As it relates to any relevant history within the past 10 years, I'm asking that for the record that Ms. Tyson with pretrial services for the record be able to give any convictions in the last 10 years. And so we're asking that the bond remain as is with Ms. Tyson's also recitation of his history.
Your Honor, he does have a felony conviction out of Gwinnett County for financial transaction, card fraud, and identity theft fraud when using, possessing, identifying info concerning a person. That's from 2018. He does have another felony conviction out of Carroll County, and that's for entering auto. 2 counts of entering auto. Looks like 2 counts of financial transaction card fraud, hit and run due to a driver to stop, and felony willful obstruction. That's from 2017.
Oh, that's good. Thank you.
Your Honor, that Carroll County matter is one of the holds.
Mr. McLean, I've read I was not the one who did the initial appearance. I've read the warrant as issued by the City of College Park police officer.
Yes.
I've also read the warrant for his open felony case 24 PI 001617 that for an battery incident from January 15th, 2024. And that by taking Mr. Neal, the allegations set forth in both warrants are extremely, especially in our particular case, are quite egregious. And I'm sorry, I failed to see the the allegations of this bond being unreasonable? Mr. Clifford, this is a reasonable bond, given the allegations set forth against you in both this case and in the felony case you have, as well as given your criminal history record. You do not qualify for a signature bond. Thank you. Next case, please.
We can go to position number 39, David Wright.
Mr. McLean, Mr. Neal's open felony case is 24 PI 001617.
Not 147, got it. Okay.
I'm sorry, Ms. Vigiletti, could you repeat the position number for your client's case?
This is position 39, Judge.
That's right.
Donna, this was the one I believe Ms. Vigiletti.
Right? Yeah. And have you all hashed out the terms?
I did receive them, Your Honor. I just need a brief moment. We proceeded to that case directly after.
Oh, I'm so sorry. Yes, you did. I apologize. I think I need to have you cloned. So. Okay.
And I think I see the difference here in Ms. Vigiletti. You could correct me if I'm wrong. Just as I'm looking at it briefly, but is it the days that is at issue? We are asking. Maybe.
Yes, so there's a slight difference in the fines. It looks like Ms. Bach recommended the statutory minimum of a total of 1,300. And there's a difference in the community service. Similarly, Ms. Bach recommended the statutory minimum of 40 hours of community service. She also recommended 12 months of probation rather than 24. And she did note that there will be a 1-year license suspension, which I believe would happen either way. I believe that's statutory.
Okay, so the fine that was the fine that was asked for by Deputy Falk was $1,300. Is that correct?
Yes, sir.
All right, and I'll definitely concede to the 13. I believe that it's 1,600, so 1,300 I'll concede to. As it relates to the community service, I do think that there's a point of contention there only because of the history and the driving history in particular. So I am asking for the 200 instead of 240 hours of community. Is it 240 hours? 120 hours of community service. And what was the third point? I'm sorry.
Ms. Bach's recommendation was 12 months of probation rather than 24.
So yes, and that probably was based on the amount of community service asked for. If you will agree to the 120 and can complete that within 12 months, I'm fine with that.
Okay, great. And then the only other difference, this week's offer, in addition to the alcohol and drug evaluation and treatment, asked for 2 AA meetings a week, where Ms. Bach was just recommending the alcohol and drug evaluation and then complying with that treatment.
I think that was based on the history. I was just asked for 2 for a total of 6 months. 2 AA meetings for a total of 6 months. Based on the criminal history.
Okay, well, thank you. If I may just speak with Mr. Wright very, very briefly, make sure we're on the same page. Okay, could you mute us real quick?
Forgive me for that, but thank you for giving us that moment.
But yeah, thank you.
In open court.
Mr. McLean, do you have a case that I can address while I'm waiting?
Your Honor,
Yeah.
may I please ask if you could address the case of State of Georgia versus Josette Lewis?
And who are you, ma'am?
My name is Katrina Williams. I'm the attorney for the defendant. We filed a motion to lift the bench warrant.
That's the
Oh.
DBW warrant, calendar, Your Honor.
Okay, I'm so sorry. Yeah, on your Zoom panel, it would be helpful if you wrote the word attorney before your name. That would
Oh, yes,
alert me.
ma'am.
All
Yes,
right, otherwise I just assume it's gonna be a witness or a victim.
Uh,
Yes, I do have a bench warrant matter. I appreciate that. Thank you. Okay, I have only this case and it's your client Josette Williams. Josette Williams, if you could please appear on screen.
yeah. Miss Lewis?
Hello.
Yeah, Miss Lewis.
Oh,
All right, now lower
yes.
the video so we can see you.
Oh, sorry.
Lower the video. Lower the video so we can see you.
Oh, like all the way like this. Is it on me?
I can't, I push it back or put it,
Oh.
yeah, that's better. Thank you. All right. This is State versus Josette Tatiana Lewis, 20 CR 004-593E. Ms. Lewis has filed a motion to set aside a bench warrant. It appears that the bench warrant was issued on May 26, 2022 for failure to appear before Judge Eric Richardson on May 25th, 2022 at 1:30 p.m. It looks like she had a prior failure to appear on June 7th, 2021 as well. So Ms. Lewis, just to let you know, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Ms. Katrina Williams is your counsel. All right, yes, Ms. Lewis?
Yeah, okay, Your Honor, Miss Lewis got into, there was a misunderstanding that led to this arrest between her mother and her younger sister at the home of her mother. Miss Lewis was arrested and she was also issued a stay away clause in her bond condition. Ms. Lewis was not allowed to have contact with the mother, her sister, or the residents. At that time, Ms. Lewis did not have a different address, and all of her notifications were going to the home of her mother. So she was not receiving these notices. Ms. Lewis has went through some instability for a period of time. She's a very young person. She was kind of like couch surfing with friends and different family members. And she has recently gained some stability, hired an attorney. I've entered my appearance so she can kind of handle and get this matter addressed.
Where was she for all of the 2 years that she failed to appear in 2021 and 2022?
Okay, well, for 22, I think this matter kind of went still for quite some time. I think because of the COVID.
We were at the tail end of COVID by the time 2022 rolled around.
No,
Judge
yes, Your Honor.
Richardson did not issue a bench warrant in 2021.
Right, I don't think there was any hearings prior to. I think those were the first 2 hearings. So there was arrest in September of 2020, and then it took about a year or so for her to even be called back to court. Do you see what, like, you know, it wasn't like 3 months later or 4 months later. There's quite some time period that had passed between court dates. And Ms. Lewis could tell you a little more about where she actually was. I just know that her housing was unstable. And she's in a new relationship and she's found some stability with her current boyfriend. She has an address. She's in McDonough, Georgia. They've hired counsel. I've made my appearance. I'll be filing motions and trying to get in contact with the solicitor so we can get this matter resolved. She has no intentions on missing any further court dates, Your Honor.
All right. Mr. Pierre Thomas, do you have any comment on this?
No comment, Your Honor. The state will defer to the court. I just wanted to know if Ms. Williams received the offer from today. I can put it in the chat for if she'd like. But Your Honor, the state is just looking at and concerned about the idea that she failed to appear at plea and arraignment in 2021, that it was then subsequently rescheduled by the same judge, Judge Richardson. She failed to appear at the arraignment. And so we have little to no faith in her, her ability to show up to trial or show up to court. I just defer to court in the matter.
All right. Mr. Pierre Thomas, have you communicated the offer to Ms. Williams in the chat?
I'm putting it in the chat now, Your Honor.
All right. Okay, Ms. Williams, I'm not going to set aside the bench warrant. I'm instead going to modify her bond to a $2,000 signature bond through pretrial services. She will report to the Fulton County Jail before 5 p.m. tomorrow, where she will be processed and then released on a signature bond. Then she'll be required to report to pretrial once a month. The original conditions remain in place. She's to have no contact with her mother and sister and to stay away, and to always maintain a current mailing address with the court at all times.
Judge, is that 1,000 on each charge?
Yes.
Okay, Your Honor, so she must report to Rice Street?
Rice Street before 5 p.m.
Yeah.
Before 5 p.m. today, and she'll be
No,
processed
tomorrow.
tomorrow.
Mhm. The sooner she does it, the sooner she gets it behind her.
Okay, Your Honor, and she'll be released on a signature bond?
That's right.
Okay, could she report today?
What happens is that she will report to the Fulton County Rice Street Jail. They will process her through intake. Then she will get a interview with pretrial services, and they will give her the information on where to attend her orientation, and they will set up the schedule for her when and where to report. And I will allow for level 1 email reporting. Ms. Tyson is our pretrial officer.
Okay, Your Honor.
Yep, all right. And so it'll be level 1 email reporting. And this way she will not only be required to report, but also be monitored to make sure that her address is current with the courts, that she complies with the conditions of her bond. And if she wants to consider the plea offer that's made to you today, then she can request a hearing with the clerk's office, or you can.
Okay, I'm gonna ask the state, if I provide you with can you email me that offer?
The offer, of course, if you put it in the chat and give me a while to copy and paste it.
Well, let me just snap it really quick. And we'll talk. Do I have your contact information?
I can put it in the chat for you.
If you could.
All right, Ms. Lewis?
Yes, ma'am.
Do you understand? You'll have to report to the Fulton County Jail before 5 p.m. tomorrow. And then
Yes.
you'll be reporting to pretrial services in accordance with the instructions you will receive.
Yes, ma'am.
All right. Failure to report to pretrial, or if you get arrested again for anything else, can result in the signature bond being revoked and converted to a cash bond or a surety bond.
Okay. Thank you.
All right. Anything else, Ms. Williams?
No, Your Honor. Thank you so very much.
All right. I will issue the order, and hopefully I'll get it done before 3 p.m. today, so it'll be with the jail records by the time she gets there. So maybe just defer going there until tomorrow morning.
Okay, Your Honor. I just
Oh.
don't want her to end up having to spend the weekend, if at all possible. It is a holiday.
Exactly. So,
Yeah.
but she'll definitely be processed at intake, and like I just went through the procedures. Okay.
Thank you so much.
All right. Thank you. All right, Ms. Lewis and Ms. Williams, you're free to go. Courtroom. Ms. Vigiletti, are we ready with your client, Mr. Wright?
Yes.
Okay. Mr. Wright, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Mr. Rhodes, what are the terms of Mr. Wright's plea offer?
Yes, Your Honor. As it relates to Mr. Wright, position number 39, count 1, state's recommendation is 12 months probation And that he served 12 months to serve 56 days. Credit for time served on 28 days, and that if he receives 2 for 1, that would satisfy those 56 days, and that the balance be on probation. That he undergoes alcohol drug evaluation and treatment. He also undergoes a risk reduction course, and that the fine for count 1 be set at $300, a $300 fine.
This is for the DUI?
Yes, for the DUI, Your Honor.
So it's not the statutory 1,000?
Yeah, I need to switch those. It's 1,000 for the DUI. I confused that with count 2, Your Honor. 1,000 for.
Okay, I'm following you.
And as it relates to the community service, we're asking for 120 hours of community service, and that he does participate in the victim impact panel. We're also asking that he attends 2 AA meetings a week for a total of 6 months. As it relates to count 2, Your Honor, we're asking that the sentence to be 12 months probation to run concurrent with count 1. And that he served the same 56 days with the credit for the 28 days already served. And if he receives 2 for 1, that would be satisfied. And that the balance be on probation. And in that one, we're asking for a $300 fine. So the total fine would be for $1,300, Your Honor. And that counts 1 and 2 run concurrent with one another.
Okay.
Thank you, Your Honor.
All right, and Mr. Rhodes, will this be a second DUI in 5 years? Ms. Vigiletti?
I do not know if it's within 5 years. I do believe it is a second conviction, but I can grab my laptop and double check if no one else has it up.
I was just curious whether this was his second in 5 or second in lifetime.
I believe it's the second in lifetime, but there was a total of 3 that I saw on his criminal history. I did ask Ms. Tyson as to whether or not there were a total of 3 in lifetime. I don't know if she had a chance to check that yet.
Ms. Tyson, would you be able to clarify? Sorry, maybe pre-trial, Ms. Tyson, are you available, ma'am? All right, so. Ms. Tyson? I think she may be having technical problems. Yeah, she thinks she left the Zoom to come back in.
I am showing that there was a cycle number 14 of his GCIC. There was a DUI, and that was in 2020. And then there was a subsequent one, cycle number 15 was a DUI, and I believe that was in 2021. However,
Mr. Rhodes, are those arrests or convictions?
those are arrests.
Okay.
I do not have the dispositions of them.
Okay.
Cycle 14 and 15.
Right. Ms. Tyson, you're back on Zoom. Would you be able to chime in?
Looks like she might have. Oh, there she is.
So this DUI arrest was from 2020. Could that be one of them?
That could be one.
And then Mr. Wright believes he has a prior conviction of reckless driving. He doesn't believe he has a prior DUI.
I'm entertaining making a decision that his license be suspended for 1 year while the entire time that he's on probation, that he won't be entitled to any kind of reinstatement offered by the Department of Driver Services until he complies with probation. So given that, I'm very curious to know how many DUI arrests he's had in his past and since today, and what were the dispositions. Ms. Tyson, would you be able to link in with us?
Yeah, sorry, I lost my audio for a second.
Yes, perfect. We are dealing with position 39. Mr. Wright is facing a DUI conviction today. I just need to know how many prior DUI arrests has he had and convictions, if any.
So it looks like he's had 2 DUI arrests. So one in 2021 indicator, but they don't have a disposition listed on the GCIC for that case. And then
Okay.
he has another from Atlanta, and that was in 2020, but it was with Atlanta Municipal Court. And it just says, the disposition just says that it was bound over November
would be-
16th of 2021.
Which would be this case.
Right.
Was the incident date December 8th, 2020?
Yes, that is it. Yes, Your Honor. That is it. So he's
So
only
he's-
had one previous, and that was out of Decatur.
Okay. So he's had this DUI, and then subsequent to that, he's had another DUI arrest. Okay. So that's my, that would be my requirement, that he not drive and that his license remains suspended for 1 year after, while he's on probation. So given that information, are we still moving forward with the plea?
That is what we discussed, Judge. So I think we are ready to move forward. I did have one additional small request. Mr. Wright did lose his job upon arrest. He does drive a forklift, so he is employable. But I'm wondering if you would be willing to.
He's not driving while he's on probation, so he can put that forklift job on the shelf for a while.
That's a great point. And even all the more reason, Judge, he is going to need a little bit of time to get a job. And so we're just wondering if you'd be willing to waive a couple months of his probation fees to help him out so he can get started on probation and find a new job.
I will waive probation fees for March, April, and May.
Thank you, Judge.
And he needs to understand that he'll be subject to random screens by probation for alcohol and illegal drugs, in addition to whatever the AA meetings are going to require him to do.
Understood. Mr. Wright did just want to make sure the court was aware, and I'm sure you are, that he is going to be released to Douglasville, so he isn't going to be able to report right away. He'll be released to his hold.
Yeah, his probation will be told until he's ready to report.
Okay. Okay, thank you, Judge. I think we're prepared to proceed.
All right. And do you stipulate to the factual basis, venue, and ID?
We do, for the purposes of the plea.
Mr. Wright, have you consumed, ironically, any medicine or alcohol recently?
No.
Okay, you'll need to speak up because this has to go on the record.
No, I haven't.
And have you understood the proceedings so far?
Yes, I have.
Are you satisfied with your legal services?
Yes, I am.
And are you entering this plea freely, willingly, and knowingly?
Yes, I am.
Do you understand that if you decide to plead guilty to these charges, that you will have to give up your constitutional right to a trial in front of a judge or a jury? You will not have the assistance of counsel to go back to a court of law, to confront your accuser, challenge the evidence and the witnesses brought before you, to be able to present any arguments, defenses, or mitigating factors if you choose to do so, and have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
Do you understand that you will not have a right to file an appeal from this decision?
Yes.
And do you understand that entering a plea to DUI can have a negative impact upon many facets of your life, including your residency, if applicable, as well as any professional licenses and your job?
Yes.
Are you still willing to move forward?
Yes.
How do you plead to one count of driving under the influence of alcohol less safe from December 8th, 2020?
Guilty.
How do you plead to driving while license suspended or revoked from December 8th, 2020?
Guilty.
Your sentence for the DUI is going to be 12 months to serve 56 days, credit for time served 28 days. Once you have resolved all any and all holds that you have, you will immediately report to the Fulton County Probation Office, where your probation in this case will commence. Do you understand?
Yes.
You must report on the first available business day, which will be Monday, Tuesday, or Thursday, and the probation office is located at 132 Mitchell Street in downtown Atlanta. I will waive your probation fees for the months of March, April, and May. From June 1st, well, let's put it this way. Ms. Thomas, let's correct the probation record. I will waive your probation fees for the first 3 months, starting from the month that you report in. Do you understand?
Yes.
Okay. While you're on probation, you will complete an alcohol and drug evaluation and submit yourself to any treatment and counseling that's required. That treatment and counseling may require you to enroll and attend AA meetings. Also, as part of your conditions, you're to enroll into AA meetings and for a minimum of 6 months, and you are to attend those AA meetings a minimum of twice a week.
Mr. Wright, is in counseling already for substance use, and he was just wondering if submitting proof of that counseling. can
No.
count. Okay.
No. The 6 months counts from the time he starts with probation. So if he's already in counseling, that's excellent. He'll just need to do an additional 6 months with a minimum of two meetings a week. I have no problem with this condition, considering that he had a subsequent DUI arrest.
Yes, understood, Judge. Yeah.
Are we still moving forward?
Yes, yes, Judge.
As I said, from the time that he begins probation, he's to immediately enroll in or continue with his AA meetings for a minimum of additional 6 months or longer if required by his counselor. But my condition is minimum 6 months with 2 meetings a month. He's to complete a risk reduction program, and that must be done within 120 days of being released. He is to complete 120 hours of voluntary community service, and that is, he's to begin his community service within the first 30 days of reporting to probation with a minimum of 10 hours per month. He has to do 1,220 hours, so a minimum of 12 hours per month, with the balance remaining of doing more on the last month. He's to attend and complete 1 victim impact panel with probation and pay $1,000 fine for the DUI charge. For driving while license suspended, that will be 12 months concurrent with count 1, and he's to pay an additional $300 fine. His total fine is $1,300, so he must make a minimum payment of at least $200 a month, beginning within 60 days of reporting to probation. Thank you.
Thank you, Judge.
You can go to jail for his iPhone.
Thank
All right. We have a position, this is on the probation calendar.
Okay.
Position 3 and 4, Mr. Phelps.
I do need to speak with Mr. Phelps briefly. I tried to come see you yesterday, sir, and they were not able to find you.
All right. Mr. McLean, do you have a case to address in courtroom 2? Oh, before you leave, Ms. Vigiletti, are you using your device to go into a breakout? Okay.
I'm logging in right now. Thank you.
Thank you.
We can do position number 2, John Billups.
Okay.
That's
And-
correct. That's a negotiated plea.
Thank you. Jail court iPhone, you're going to see a message on your screen to join a breakout with Ms. Vigiletti, okay?
Okay.
Thank you. And she's connected. This is John Lee Billups, 24 CR 1183B. Mr. Billups is accused of criminal trespass and theft by taking from March 13th, 2024. Mr. Billups, you have been advised of your right to remain silent, and your attorney is Mr. McLean. Mr. McLean, how are we proceeding?
Negotiated plea, Your Honor.
All right. Mr. Billups, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Since you have a mask and you're putting your hand up, you'll need to speak extra loud, okay? Because I needed to get it on record. Thank you. All right, Mr. Pierre Thomas, what is the recommendation, please?
Your Honor, the recommendation from the state as it relates to count 1 criminal trespasses for the defendant to serve 12 months on probation. That is to be concurrent with count 2, which is theft by taking in its misdemeanor form. The recommendation for count 2 is 12 months probation for the defendant to serve 32 days in custody, credit for the 16 days that he's already served. Looks like he was booked in on March 13, 2024 until today. For the balance to be probated, for him to stay away from 38 Peachtree Center Avenue, Northeast Atlanta, Georgia, which is a Georgia State University property, for him to complete an anti-theft course and to complete 40 hours of community service. Nothing further to add from the state. If we can get the defense to stipulate to venue, factual basis, and ID, that'd be greatly appreciated.
We do so stipulate for the purposes of plea today.
Ms. Tyson, if you have a moment, could you give me his history, please?
Okay, you said this was Mr. Phelps.
Yeah.
Okay, one moment.
No, I'm sorry, Mr. Phelps is the person I should be meeting
No,
with, I
not
believe.
Mr. Phelps, Mr. Billups, position 2.
Put your signature there, please.
If I'm not mistaken, this was a situation where I kept him away from all GSU property because there have been repeated incidences of encounters with Mr. Billups in different locations of GSU property, and he's got a hold as well.
Your Honor, he has 39 arrest cycles beginning in 1986. Let's see, his last arrest. See, it was January 9th, 2021, and that was for criminal trespass, theft by taking, and criminal damage to property in the 2nd degree. Looks like that case was dismissed May of 2023.
Yeah,
See.
that's good, Miss
Okay.
Tyson. I appreciate it. Yes, this is the gentleman who's been banned from all GSU property. He's got a permanent ban, not just at 38 Peachtree Street. So I cannot accept this plea offer based off the ban. So Mr. McLean, your client will have to agree to stay away from all GSU property, not just 38 Peachtree Street, because
Is that acceptable to you? Stay away from all real estate property? Yes, that is acceptable.
all right, then Mr. Pierre Thomas, please continue. So this was stay away from all GSU property. And is he going to continue on probation?
Yes, the balance will be probated and he would complete the anti-theft course and the 40 hours of community service.
Mr. McLean, other than the amendment of staying away from all GSU property, which is quite extensive in downtown Atlanta, anything else to add?
It's almost like we need a map because it is several pieces and parcels here and there. Yes, Your Honor, that's fine. He'd like to go forward.
Mr. Billups, have you stipulated to the factual basis venue and ID, Mr. McLean?
We do so stipulate, Your Honor, for the purposes of the plea. I'm looking down simply, Your Honor, because I'm writing up the different conditions.
Okay. Mr. John Billups, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
And have you understood that you have a ban? You cannot return to any building that belongs to Georgia State University.
Yes, ma'am.
And that if you violate that, you'll be back in jail and you could end up spending the rest of the year in jail for this particular case.
Yes, ma'am.
If you decide to move forward with this plea, you would have to give up your constitutional right to a trial. You will not be able to go back to court, confront your accuser, challenge the evidence brought against you, present your own defenses, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Ma'am.
I can't hear you.
Yes, ma'am.
How do you plead to 1 count of criminal trespass at Georgia State University and 1 count of theft by taking?
Guilty.
Your sentence for theft by taking is 12 months to serve 32 days, credit for time served 16 days, to stay away from all property belonging to the Georgia State University. While you're on probation, and then it will be for the criminal trespass, it will be 12 months probation concurrent with count 2. While you're on probation, you will report to probation every month, and you will begin on April 1st, next Monday before 3 p.m. at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will undertake an anti-theft class, and you must enroll in that class within 90 days of being released. So within 3 months, you must show proof that you have got an appointment to take that class. Do you understand?
Ma'am.
You are to also complete 40 hours of community service with any nonprofit agency that's not a church or not a school, and you must begin with a minimum of 5 hours per month, beginning with the first 30 days of probation. If you return to any GSU property, probation's authorized, and you are arrested for trespass again, probation's authorized to revoke your probation and have you serve out the rest of the time in prison. Thank you.
Your Honor, in transferring the papers, I lost a digit on the case number. It's 24CR00. I've got a 118, but
1183 B.S. in Billups.
thank you. Got it.
All right. Next case in courtroom 2, please.
Position number
Now here's your requirements.
15 and 16, Kenneth Lewis.
You go and send it to that one. We ask you to, you get this address and phone number. Yeah.
Is that your client too, Mr. McLean? Kenneth Lewis?
Yes, Your Honor, he's coming up.
All right. Mr. Lewis has 2 cases, each of which have 1 count of theft by shoplifting, 24 CR 1193H and 24 CR 1197H. Mr.
Your-
Lewis? Yes, sir.
On 15 and 16, one of those 2 had notations as to an uncalendared or rather unnumbered case in addition to that. So there are 3 theft by shoplifting.
That is correct.
May I have that case number?
It is going to be 24 CR 001373H.
Okay, thank you. And is that also 1 count of theft by shoplifting?
That is correct, Your Honor.
Thank you, sir.
Could
All right,
you
so
repeat that? 24 CR.
001373H.
Got it. Okay.
Right. So with regards to these 3 open cases, each having 1 count of theft by shoplifting, Mr. Lewis, you have been advised of your right to remain silent, and your attorney is going to be Mr. McLean. Mr. McLean, how's your client moving forward today?
He is pleading guilty, Your Honor, to all.
All right. Ms. Tyson, does Mr. Lewis have any prior shoplifting convictions? Or Mr. Pierre Thomas, if you want to chime in.
I did not see it, Your Honor. I do believe that this is his first, although he's charged with 3 on the calendar, this would be his first conviction, would ultimately result in his 3rd conviction, meaning his next conviction would be a felony.
Well, I'll say that's the first for me. So, Mr. Lewis, if you decide to plead guilty to all these 3 cases, this will be 3 theft by shoplifting convictions on your record. And you are 29 years old? Okay. So any subsequent arrest from now on, if you get arrested again for theft by shoplifting, that will automatically be a felony charge. Which means that you will be in the Superior Court of Fulton County and you'll be not looking at sentences of less than a year, you'll be looking at sentences of more than a year. So are you still willing to move forward with this plea? Mr. McLean, is your client still willing to move forward? I'm sure you've already advised him accordingly.
I have.
Okay. Mr. Lewis, please raise your right hand.
I have a question.
Yes, sir.
So are these three, shoplifting for Walgreens? It says Walgreens?
This will be 3 separate convictions. There will be 3 separate misdemeanor convictions. If you repeat again, I can't hear you.
He's asking about Walgreens, and I had told him that the state is going to read out the location of each one. So as we proceed.
Okay, yes, I understand, Your Honor.
We had seen it in the offer and in the documents, Your Honor.
Okay. All right. So in that case, Mr. Lewis, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
All right, and you're gonna have to speak a little louder, okay? I do understand. No, you don't lower the mask. You just need to speak louder because it needs to be recorded.
Yes, ma'am.
Thank you. All right, Mr. Lewis, Pierre Thomas, excuse me. Yes, sir. What is the plea offer for all 3 cases?
Your Honor, the state will give it in sequential order by the offense date. Case ending in 1193H. Offense date is February 19, 2024. The offer in that case for theft by shoplifting is for the defendant to serve 12 months on probation, to serve 34 days in custody, credit for the 17 days that he's already served. He looks like he was booked in on March 12, 2024 until today. For the balance to be probated, for him to stay away from Walgreens located at 4617 Jonesboro Road in Union City, Georgia, and Fulton County, Georgia. As it relates to the next case, offense date of February 28, 2024, case ending in 1197H, for the defendant to serve 12 months on probation, to serve 34 days in custody, credit for the 17 days that he's already served. He looks like he was booked in same time, March 12, 2024 until today. Balance probated, stay away from the same Walgreens located at 4617 Jonesboro Road, Union City. And lastly, Your Honor, the offense date on the last one is February 26th. So these are, I'm sorry, they're not in sequential order. The last one was February 26th, 2024. The case number ending in 1373H. It's for the defendants to serve 12 months on probation, to serve 4 days, credit for the 2 days that he's already served in custody. One moment.
Yeah, he was released.
Okay, he was released on a signature bond. That is correct. He was booked in on the March 3rd, 2012. I'm sorry, March 3rd, March 12th, 2024, for the balance to be probated, for him to stay away from the same Walgreens, 4617 Jonesboro Road, Union City in Fulton County, Georgia. So all of these are to run concurrently. He had the luxury, I guess, of being arrested for all of these at the same time. And so the state is not seeking for them to be served consecutively or not seeking to recidivate in any way. But we do like to point out that any subsequent arrest, as Your Honor has already stated, would be subjected to a felony in Superior Court. Nothing further to add from the state.
Mr. McLean?
Your Honor, he asked the court to accept his plea. He's going to be staying away from shoplifting.
I'm going to require an imposition of an anti-theft class. I've not heard that from the state. Is there a reason why we are not eliminating that?
The state, just because it's limited criminal history, but the state would like to add it if it is something that the defense would like to accept.
He and I have discussed that notion, and he is amenable.
Okay. And is there a particular reason if he needs to go back to a Walgreens, or would a CVS pharmacy do, or any other, if he needs to fill out a prescription or anything to that effect?
I think a CVS would do, Your Honor, and a person can always ask a friend to go into a store instead of going in themselves.
So in that case, it's going to be from all Walgreens, not just the little store in Jonesboro Road Mall, Union City. Since he seems to have a remarkable attraction for that location.
I understand, Your Honor.
All right, Mr. McLean, I do believe you stipulated to the factual basis, venue, and ID.
We have.
Mr. Lewis, have you consumed any medicine or alcohol?
No, ma'am,
And have you understood the proceedings so far?
I do.
And are you satisfied with your legal services?
I am.
And do you understand that if you decide to move forward with this case, that you would be having 3 theft by shoplifting convictions on your record, and any subsequent arrest will be automatically be a felony charge?
Yes.
If you decide to move forward, you would have to give up your constitutional right to a trial. You will not be able to challenge these 3 cases in a court of law in front of a judge or a jury. You will not have the opportunity to have your counsel assist you while you confront your accuser, challenge the evidence brought against you, present any arguments or defenses, and have the state carry its burden to prove all 3 offenses against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to theft by shoplifting in cases 24 CR 1193H, 24 CR 1373H, and 24 CR 1197H?
Guilty.
These will be 3 theft by shoplifting convictions on your record. With regards to your sentences, they will be concurrent for all 3 cases, and the sentences for all 3 cases is 12 months. Excuse me, for ending in 1193 H and 1197H, it will be 12 months probation, to serve 34 days, credit for time served 17 days, balance probated, to complete an anti-theft class, and to stay away from all Walgreens stores in the state of Georgia, including the one in Jonesboro Road, Union City. You are to report to probation every month until the remainder of the 12 months are completed. With regards to the case ending in 1373H, your sentence is 12 months to serve 4 days, credit for time served 2 days, the remainder of the time to be served concurrently, same conditions, which would be the anti-theft class, and to stay away from all Walgreens in the state of Georgia. Report to probation every month beginning April 1st, 2024, before 3 p.m. That's next Monday. The probation office is located at 132 Mitchell Street in downtown Atlanta. Thank you.
Thank you, Your Honor.
Jail court iPhone, who do we have?
Well, this is the probation calendar, 3 and 4 with Ms. Vigiletti.
Yeah. Ms. Vigiletti, are we ready?
Yeah.
We are,
I need that other guy. Yeah. Make room for him.
This is Mr. Phelps, Desmond Phelps, case 18 CR 0047208, convicted of possession of a pistol or revolver by a person under the age of 18 from an incident date of April 27, 2018. His probation revocation matter is 24 PB 00385. Mr. Phelps, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. Officer Barnes, thank you for waiting. What is the disposition and the state's recommendation?
Your Honor, this matter was before the court on April the 18th of 2023, and before Judge Roth. At that time, Your Honor, the defendant was placed on probation, 12 months probation, for the offense of possession of a pistol or revolver by a person under 18 years of age. He was sentenced to do 40 hours of community service, report and pay supervision fees, and no guns or weapons while on probation. At this time, Your Honor, I am showing that he has not completed the 40 hours of community service. and he has failed to report on May 8th, 2023, June 19th of 2023, June 27th, 2003, July 11th, 2023, and July 27th of 2023. There are 243 days remaining left on this case, Your Honor. It's the request of the probation department to continue Mr. Phelps on probation.
Does he have any other holds right now?
He does, Judge. He has an open felony case. I am so sorry. And he also has a felony probation violation holds as well.
So the open felony case from March 7, 2024 is possession of a sawed-off shotgun, receipt and possession or transport of firearm by convicted felon. All right. Ms. Vigiletti?
Yes, Judge. I talked to Mr. Phelps. He did tell me he's been working on the community service. He's not done yet. He estimated he's completed about 15 hours. He has been arrested now on possession of a firearm, which of course would violate probation, but he intends to fight that case. He says he's not guilty. And so he is looking very eagerly to get put back on probation. There are lots of days left on probation still. I think we have over 200 here to give him a chance to report, show that proof of community service he's done so far and continue and finish out that sentence. So we're just asking that the court accepts the recommendation of the probation officer this morning.
Has he made bond in the felony case, the $42,000 bond?
He has a bond hearing or a preliminary hearing of some sort on April the 4th or the 8th, sometime in early April. I think what is holding him, the biggest thing that's holding him right now are the felony probation violation cases. So I do intend to flag to the felony probation clerk's office that he needs to be added to the calendar for a hearing on that as well. So there is quite a bit holding him as of right now.
Your Honor,
yes, Mr. Barnes?
Just for clarification, are these new charges that he's currently in jail for?
Yes, sir. March 7, 2024. He was booked in on that date.
Because these are new charges and the charge that he's currently on probation for, the revolving gun and weapons charges, may the court also advise Mr. Phelps that if he does plead guilty or found guilty on those particular charges, that it will revoke his probation or they will violate this particular probation?
Yes, we did discuss that this morning. He is aware and he does say he's not guilty and he's going to be fighting that case.
Understood. Contrary to the state's recommendation, the court is revoking his probation and he's going to serve out the rest of the 243 days at the Fulton County Jail, less the 22 days that he's already served. He will not continue on probation and he will complete the rest of the time for this case.
Understood.
Thank you.
Your Honor, that concludes my business. May I please be excused, Your Honor?
Yes, Officer Barnes, you have a great weekend. Thank you.
Thank you, do as well. And the court's name I'll be over.
That's a question.
Officer, jail court iPhone. I'm sorry. Yes, Mr. Phelps.
So what, y'all ain't what's going on?
Ms. Vigiletti, your client is inquiring. The court has revoked your probation from the possession of a firearm by an individual under the 18 from your 2018 incident. You have 243 days left on your probation for that case. The court has revoked the probation, so you're being given credit for 22 days, and you have 221 days left to serve on probation in the jail for this case.
So I gotta stay locked up for this?
Yes, sir.
For 200 days?
221 more days.
2 for 1 though, right?
I don't know. That's up to the sheriff.
Oh, I ain't get what they saying.
I'll explain it to you.
All right.
Thank you.
All right.
Officer Goldie, let me know if I need to come up there and have another conversation, okay?
Yes, you can.
Okay.
Ms. Vigiletti, who do you have seated next to you? All right, Officer Barnes, I think we concluded. Thank you.
Thank you, Your Honor. Have a great day.
You too. 27, okay?
And 27.
Okay.
So this is my client Contavious Shields, and I believe he does have family present this morning.
All right, ma'am. We are addressing Kentavious Shields with two separate cases, 24 CR 001233E, accused of battery, family violence, and criminal trespass from February 7th, 2024. Mr. Shields' second case is an additional count of battery, family violence from March 2nd, 2024. Mr. Shields, you've been advised of your right to remain silent, and your attorney is going to be Ms. Vigiletti. Ms. Vigiletti, how are we proceeding?
Judge, we would like to make a bond request this morning.
All right. Would you like me to arraign this case, or would you be filing a waiver?
I can file a waiver.
All right. Positions 26 and 27 will be an entry of a not guilty plea. Counsel will file a waiver of arraignment, and the cases are further notice for trial. All right, let me just go ahead and pull up the bond orders, please. From the February 7th, 2024 case, Mr. Shields has a bond of $5,000. It's a surety bond and no contact with Michaela Harris, and to stay away from Hall Street and John Wesley Dobbs. With regards to position 27, Mr. Shields has got a bond of $3,000 surety bond. Same alleged victim, same stay away. Yes, Ms. Vigiletti?
Yes, Judge. So Mr. Shields has been in custody for about 2 weeks now. As you said, his total bond is set currently at $8,000 surety bond, and we are requesting a bond reduction this morning. Of course, this court considers the length and character of Mr. Shields' residence here. He has lived in Atlanta all his life. He has significant community that's here to support him. His mother is here and he has many siblings. They're all very supportive. They don't have the money to pay an $8,000 bond, but they are physically here today and they are here to ensure that Mr. Shields comes to court. The complaining witness in this case, Michaela Harris, is also here today. While they do not live together, they are still in a relationship. They do have a 6-month-old child together, Malachi. Michaela tells me, and she is present, so you can't speak with her, but Michaela tells me that Mr. Shields is an excellent father. He actually has Malachi every day. He was working in a kitchen. Of course, upon arrest, he did lose his job, but he's a highly employable person. Because restaurant work here in Atlanta, there's lots to do. He wants an opportunity to get back to work. I don't think we have to worry because of his large community here and folks who are here to support him today, that he won't show up for court. He does also have a hold in Newton County. It is a probation violation hold, is my understanding. And so while he awaits trial, there is a dispute of fact in these cases. And while he awaits trial on this case, is just looking for an opportunity to resolve that hold in Newton County, get back to work, get a new job, get back to work, be there for his 6-month-old son, Malachi. And Michaela did also just learn that she is pregnant with their second child. So also support Michaela in her pregnancy and doctor's appointments.
Ms. Tyson, may I have Mr. Shields' GCIC, including the details of his hold?
Mr. Shields, he has 3 arrest cycles beginning in 2018. He has 1 FTA. It's It's from 2019. And he has one arrest cycle out of New York that resulted in a misdemeanor conviction for possession of a weapon in the 4th degree. Disposition date on that case was May 27th of 2022. See, I don't have any information that popped up with his with the hold on his GCIC.
I will add, I forgot to mention it, Mr. Shields did tell me that he had an FTA from 2019. He is quite young. He was 18 at the time. And one thing we discussed at length yesterday is that he's grown up quite a bit in the last few years.
I can, if you want me to, Judge, I can try and run it again and see if it pops up, but nothing popped up when we ran his GCIC. I can
Well,
try again.
That's fine, but he does have a Newton Hall according to
He
the jail
does.
record, so,
He does.
all right. Mr. Rhodes?
Yes, Your Honor. As it relates to Mr. Shields, position number 26 and position number 27, I know that Your Honor probably had an opportunity to review the warrants in both these incidences involving the same victim. It appears that both of them were extremely violent. In one incident in particular, and if I'm not mistaken, that was position number 26. The victim in this particular case, Miss Harris, found herself distraught, running towards the police, and she had indicated that she was, punched in her lip, and there was visible bruising relating to that. And this all happened while she was pushing her son in a stroller, the same son that I believe that Miss Vigilante is talking about. In position number 2, when there was a stay away, Miss Harris was attempting to allow Mr. Shields to see that son on a second occasion, and he abused her violently again, for which the officers observed physical scrapes as well as bruising about her as a result of the physical violence that he did upon her. And that was less than a month later, Your Honor. I believe that was on 3/2 of 24, I believe was the date that you had given us. Those two incidents says back to back in the presence of the child. And now we're hearing that there was there's another child on the way. Don't know if she was pregnant during these particular incidences. These are 2/7/24 and 3/2/24, Your Honor. So don't know if other charges are forthcoming. You did ask about the history. One of the things I would point out is that counts 1 and counts 2 in his history was him possessing a firearm as a minor. In both of those, and in count 1, he was convicted of that. And in count 2, I believe he was convicted as well. Count 3, I'm sorry, cycle 1. And then cycle 2 is what I meant. And then cycle 3, I believe, was a probation violation. Mr. Shields, his probation was violated. And as indicated, there is a code out of Newton County. I generally like to be reasonable when it comes to bond. It just seems to me with the battery, family violence, and the criminal trespass, I believe, which was 3 and 2. And the fact that this particular victim, Miss Harris, ran towards police after the violence had ensued, I do believe that that's a reasonable bond, Your Honor. And for the second case to have happened less than a month later, there was no regard to the fact that he was in trouble from what was alleged the first time. It shows a disregard, just like his history, to possession of firearms by someone under the age of 18, and then that probation violation as well, Your Honor. I don't know where this village was when he was doing all of this, but I don't think that would make much of a difference. So I'm asking that Your Honor keep his bond, that it remains as is. I'm sorry, I don't know if someone's.
I'm sorry, Ms. Tyson, if you could mute, please. Thank you. All right, sorry about that, Mr. Rhodes. Please complete.
All right, and so as I indicated before, I'm asking that the bond remain at the $8,000 surety bond that it is. I do believe it's reasonable, and given his history, given his probation violations, his current hold, and the fact that these two events happened one after the other. Thank you, Judge.
All right,
Your Honor, and it is a probation violation out of Covington.
and do we know the underlying conviction?
No, Your Honor, it just says probation violation.
Okay,
And then the date on the warrant was June 25th of 2019.
okay. Thank you so much. Appreciate it.
Welcome.
All right, I have a lady over here with the word Samsung on her screen. Were you waiting to contribute to this case?
Yes, I'm his mom.
All right, and if you could please identify yourself.
Hi, my name is Sanika Shields. I'm the mother of Katavian Shields.
All right, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Yes, ma'am. What would you like to tell us?
I just want to let you know, my son, he's a good guy. The things he did do, he was younger, and he's been through, he's been through rough time in his younger life. He ain't been to group homes. And, he haven't had the best of the life till he found his own life with his child. So we all make mistakes when we're young. But, we have to learn from our mistakes. And he have had a rough life, living here, living there. So now he finally at an age now he knows right from wrong.
Thank you.
And yes, and he helped me a lot. I have 11 kids. He's my oldest son. So, and I have 8 grandbabies. So he helps me around the house a lot.
Okay. Thank you very much.
Okay.
Miss Michaela Harris, I do see you on the Zoom. If you want to contribute to the proceeding, you would need to unmute and start your video.
Judge, while Ms. Harris is unmuting here,
I can't really hear where I'm at, but yeah, I would like. Can y'all hear me?
I need to see you. You need to remove the hood off your head and you need to be.
Okay, hold
Where
on.
are you?
I'm gonna go to a more private area.
Okay. Yes. Anything else to add, Ms. Vigilante?
I don't know for sure where Ms. Harris is, but I do know she just got a new job. I do think it is possible that she's trying to balance a couple of things at once here. Yeah, I just wanted to add, I know that this court takes violence very seriously, as you should, but what Mr. Shields' mother is telling me is exactly what I heard from Mr. Shields. We had a long talk yesterday about what has changed for him since his youth. He is only 23. And he told me it was having his son, having Malachi, 6 months old, changed a lot for him and really helped him to grow up. I do hope Ms. Harris rejoins us. I did speak to Ms. Harris yesterday as well, and I don't want to get too deep into the facts. I know we are just talking about bond here, but both Ms. Harris and Mr. Shields have told me that there is a dispute of fact in these cases that differs from what the police report says. And I that is kind of most appropriate to be handled in a trial court setting. And, in the meantime, he could be so much more productive if he's released his hold and he's getting a job and he's supporting his family.
Ms. Michaela Harris, this is your final opportunity to start your video and unmute, otherwise I'm ruling. Miss Michaela Harris.
Yes, I'm here.
Your video needs to be on.
You see me?
Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
On both these incidences, the first one where you were having your son and Katavian meet, and the second time when he took the baby's bag, was he present when you were talking to the police?
No.
Okay. What else would you like to tell me?
I like to say, the first incident, I decided not to press charges because me and Katavian, we do have like a good relationship. We take care of our son. I know those incidents happened and it was like violence and stuff, but those incidents they were like recent. And I know incidents could develop again. But I don't think, personally, the way I know Kentavian, like his mom said, he's a good person. Like, he does what needs to be done. He takes care, he makes sure me and my son is good and that we don't want it for anything. And I feel like we could work it out to like where we both are like, where we keep a good relationship and keep like good boundaries and respect each other's space. Cause I do need him for like the financial support, emotional support out here, because it is just me out here. I don't have just nobody helping me with my son besides him and his family. But I would like him for emotional support, financial support, and to help like to be there with me through this second pregnancy as well. But that's really it. I just want to say, yeah.
Were you pregnant on March 2nd, 2024?
I don't know. I did just find out, so I have to go to the doctor and stuff. So I did just find out.
Thank you. You may mute your screen. Thank you. Mr. Shields, I'm glad your mom and your partner are here, and they clearly have good things to say about you. My concern is that you project a certain person to your parents or to your mother. You project a certain person to Ms. Harris, and then on these two separate incidences, based on the information derived by the police officers, this is a completely different person. I'm very concerned that I think you do pose an imminent threat to Michaela Harris. I do not know who is the real Kentavian Shields at the present time, because these are very different persons that are being projected. The warrant shows someone who is capable of great violence, especially in the presence of a child. Both incidences for which you've been charged not only involved Michaela Harris, but also involved a very young child being present. And what's interesting, that in both incidences, you fled the scene. You were not present when the police was called. If there's a dispute of the facts, or if there's a misunderstanding of the facts, then it raises a big question of why you were not at the scene when the police were called. So therefore, based on these factors, I do know that you have a very different persona to your mom, and perhaps a different persona to Miss Harris in good times. But these two particular bad times, there is a great concern that you do pose a threat to Michaela Harris and perhaps to your child. On each count of battery family violence, the bond's going to be amended to $2,500 surety bond. His total bond is going to be $5,000. He is to have no contact with Michaela Harris, no contact with the child that he shares with Miss Harris. He is to be equipped with an ankle monitor, for the monitoring fees shall be paid by him. Upon his release, upon making bond, he must be equipped with an ankle monitor, and the monitoring fees shall be paid by Mr. Shields. If he does make bond and he is equipped with an ankle monitor, he's not allowed to miss any of his ankle monitoring fees. If he fails to make 2 payments to the monitoring company consecutively, that will be grounds to set aside his bond and have him arrested again. No illegal drugs, no alcohol, and no weapons and no firearms. While you are out on bond, you will also enroll in a domestic violence intervention program, and you must enroll in that program within 60 days of being released. You will show proof of completion of the domestic violence intervention program by filing the certificate within the next 12 months, pending your trial of your case. That concludes. And Mr. Shields, I'm very serious. You are to stay 200 yards away from Michaela Harris and the child or children that you share with her. If you intend to see your children, you would need to file a separate legitimation action and get a superior court order with regards to visitation, custody, and child support. Do you understand? Ms. Vigiletti, if you can submit a proposed bond order, including the ankle monitor.
Okay, Thank
Your
you,
Honor,
Judge.
if I may inquire, as it relates to the position number 26, the criminal trespass count, is it the intentions that the total on that case will be 2,500, so 1,500?
I'm sorry, let me clarify.
Thank
2,500
you,
on position 26, there'll be 2,000 on the battery and 500 on the trespass. On the second case, which is the subsequent, it's going to be 2,500.
Thank you, Your Honor.
Mhm.
Thank you, Judge.
Thank you. Are we concluded with everyone in the courtroom too?
Yes, ma'am.
All right, medical, who do you have, please?
We have, position number 32 and 33, Mr. Swan.
All right, do you have anybody else after this?
No, he's the last one.
All right, sir. 32 and 33, Delano Swan. Mr. Swan, my name is Judge Law, and we are addressing your case for theft by taking under 23 CR 3924J, and the second case for theft by shoplifting, 24 CR 1109J. You have a right to remain silent about the facts of your case. Anything you add, anything you state during this virtual proceeding, your statements can and will be used against you. You have a right to an attorney, and representing you this afternoon is going to be either Mr. McLean or Ms. Vigiletti, or I'm sorry, Ms. Vigiletti, you're on mute.
I apologize. This is Mr. Swan. Last week, we discussed that he requires a conflict attorney. I just heard my name. I'm not sure where we are in the discussion.
Okay. Mr. Murphy, you're with Conflict Counsel. Would you be available to take on this case? I'm sorry, Mr. Murphy. Please unmute.
Yes, Judge. You were asking me to take an appointment?
Yes, this will be for Delano Swan, accused of theft by taking and theft by shoplifting. The theft by taking is from March 25th, 2023, and the theft by shoplifting is from February 29th, 2024.
And I'm so
I'm sorry, Your Honor, it shows Miss McLeod is on this case.
Yes,
Oh, it does? Okay.
Yes.
All right, if she's already on this case, she didn't know about this and she left. So I'm going to reset this case to next Tuesday as an add-on. Please alert Ms. McLeod that she's got a client awaiting her interview. Thank you, Mr. Swan. Mr. Swan, your attorney, Ms. McLeod, was here this morning, but she was unaware that you were on the calendar. So she'll have to speak with you before we can proceed. Thank you. Medical, do you have any other cases?
No, he was the last one.
All right. All right, Ms. Vigiletti and Mr. McLean, I'll go over the calendar with you very shortly. I'm just going to go step away briefly to do our competency calendar. Who will be in the breakout with me? Kasha and Mr. Ian Walker, Mr. Murphy, and Mr. Bartel. There we go, in courtroom 2.
You can add me too as well, Your Honor, please.
All right, Mr. Pierre Thomas. All right.
Add me as well, Your Honor. I need to make sure that I
All right, Mr. Bartel, we will include you from Ms. Meadows. You'll have to wait until the competency review is over.
Yes, Your Honor. I have my device. I can take that into another room and sign on if that's okay.
That's perfectly fine. That way courtroom 2 will be available for the next calendar. All right, Ms. Champion, it'll be quite a few individuals. It'll be Paul Bartel once he signs on. I mean, he's already on. He just needs to activate his device. Myself, Lamar Rhodes, Dennis Murphy, attorney Brendan Pierre Thomas. Mr. Pierre Thomas, you'll need your video on. Kier Burgess, Kasha, and Ian Walker. And of course, Ms. Vigilante and Mr. McLean, we are ready to go over the calendar, please. And I'm so sorry, I think Mr. Mr. Rhodes may have fallen off the Zoom, so, all right. Anyways, on the probation revocation calendar, positions 1 and 2 were continued on probation. Position 3 and 4, probation was revoked. Position 5 and 6 is continued on probation. On the bench warrant calendar, the bench warrant was not set aside. The defendant will surrender to the jail and be released on a signature bond through pretrial. I don't think I have to go over the competency calendar. I think that's already been announced. The main SAP calendar. What did we do on the add-on, Mr. McLean? Oh, that was a plea.
That was a plea, Judge.
Okay, Sharon Compton was a plea. Okay.
Yes.
So on the main SAP calendar, position 1, Bentley, is reset to April 4th. Position 2, Billups, was a plea. Position 3 was a waiver of arraignment and further notice for trial. Did we modify the bond to a $2,000 signature bond through the jail? I believe we did.
Yes, ma'am.
Okay. Position 4, Quinton Dennis. Announcements from courtroom 2. Please unmute.
He did not.
Says reset for the ASG, Judge.
Quinton Dennis was reset to what date?
Per ASG, it doesn't state a date.
They're looking into something and apparently we're not ready. He never presented at the visitation booth when I attempted to visit him. I don't know exactly why he did not present. I did hear, that was somebody else.
Yes, Your Honor, the warrant in itself, and I'm sure you can see it, but the warrant itself kind of makes out that he may have potentially been, I guess, a co-defendant or a defendant in the armed robbery that is related to the theft, I guess that's related to the theft. And so we've reached out to the agency and we're just waiting to hear back if they intend to take out subsequent warrants. And so we didn't want to proceed on this if they intended to take out a subsequent warrant for the armed robbery.
Does he have a felony hold at the present time?
I don't believe so, Your Honor.
All right, this is reset to April 4th, 24, pending a possible transfer or a plea or a waiver of arraignment. Options A, B, or C.
Right.
Okay. Position 5, Destiny Isogbu.
I did visit her, Your Honor. That had been a reset. That's the one involving the mother, and the interview wasn't very terribly fruitful. Not sure what to do with her. She needs to collect her thoughts.
Reset April 4th. Hopefully it will be collected enough to make a decision as to a plea or an arraignment.
Right, we're gonna give it another shot.
Okay. Position 6, Evans, is reset April 4th. For I think Mr.
Chuck
Douglas, yes, had indicated that he wants to pre-try the case. So position 6 and 7 are reset to April 4th pending resolution. Position 8, Roderick Harris.
Mr. Harris, I believe the DA transfer that was requested last week was accepted.
All right.
I believe. Let me double check real quick, just in case.
So Mr. Pierre Thomas, are we doing in order to transfer?
We're still waiting on an answer of whether or not they've accepted it.
Okay, so reset to April 4th pending a transfer. Jimmy Hood.
This is the case where I did send a separate email because I am recommending a reset.
And this is to April 4th, 11 a.m., correct? Okay. So, and did we request an evaluation already?
I did. I attached it to the email and I believe Mr. Bartles is taking it from there.
Okay. So reset April 4th at 11 a.m. And Ms. Grace, do you have the evaluation requirements, documents?
I'm sorry, I think I put Miss Champion on there. Miss Grace, I will forward you those documents.
Okay.
Your Honor,
Did
going
you send
back-
them did you send them as an attachment to the announcements?
No, I sent a
Oh.
separate email specifically about this.
She did.
I'm forwarding it to you right now, Miss Grace. right?
Okay, thank you.
Okay.
your-
Mrs. Meadows, Mr. Ian Walker will be speaking with you shortly. So you can either remain on the Zoom or you can leave and he'll call you.
I want to, all of us, I'd like a breakout because I'm finding different information from what I was told just last night and I don't see
Okay,
how.
please hold then while I finish the calendar.
for
Please
sure.
hold.
Thank you.
Position 10 and 11, Hodge was a plea. And, excuse me, position 10 was, I'm trying to remember the words, null pros. And position 11 was a plea. Position 12, Jackson was a plea. Position 13, Jones was a plea. 14, Jones was null pros. 15, Lewis was a for Mr. Kenneth Lewis. This was 15 and 16 and the additional case. These were all pleas. Position 17, O'Garis McGee, that was a plea. No. That was
Ms. McLeod's case.
this, yeah, she's gonna file a waiver of arraignment, and that was given a signature bond through pre-trial, if I recollect. So, Miss Grace, that would have
Yes,
been
Your Honor.
2,500
2,500 SOB through pretrial level 1.
Okay, excellent, thank you. William McGee was a waiver of arraignment and further notice for trial. 19, Jeremy Miller was a plea. 20, Simone Mitchell.
She was released.
Okay, thank you. That's further notice for trial. 21, Clifford Neal was a waiver of arraignment and further notice for trial. Bond remains the same. 22, Chastis Ray Nixon for 22 and 23. Announcement.
Your Honor, we were told that there was a reason why he refused the interview and that it was volitional. So we are thinking that we're going to give it another shot at visiting him, and if it's a refusal again, we'll have to get to a plan B.
Okay. Positions 22 and 23 are reset to April 4th. Refusal to interview would be the reason. 24 and, excuse me, that was 22 and 23. 24, 25, Shavers.
He was released.
All right, this is further notice for trial. 26 and 27, Shields was a waiver of arraignment and further notice for trial, and he's got a modified bond. And Mr. McLean, you're submitting the modified bond order, correct?
That is mine, and yes, I will submit.
Okay, thank you. 28, Sissoko was a plea. 29 is null prost. 30, Slater is a plea. 31, Steed is a plea. 32, Delano Swan is reset to speak to Ms. McLeod, reset to April 4th. 34, Alex Williams was a plea. 35, Cedric Williams is a waiver of arraignment and further notice for trial. And well, it's a waiver of arraignment, but I understand that his case has already been accepted by the Superior Court and has already been, well, right now, just accused as 24 PI 001972. Mr. McLean, was that your case?
Yes, Your Honor.
Okay, so there's nothing to reset then in that matter. And if you want to not submit your waiver arraignment, that's perfectly fine with me too.
Right, understood.
And Mr. Pierre Thomas, I don't know whether, since it's already been accused as a felony case, whether I need to do a transfer order.
What position is this again? I'm sorry, Your Honor.
35, Cedric Williams.
I think we've already submitted that for signature. Yeah.
All right. Then in that case, moving on to 36 and 37, Gabrielle Williams.
Yes, Miss Williams, I spoke with her yesterday. She's actually requesting the reset. She's currently working with our social worker to secure some housing, so she wants to get that together before she proceeds.
Reset to April 4th, 2024, 36, 37. 38, Ricky Wilson.
Mr. Wilson. Let me take a look here. Mr. Wilson, I did file a waiver of presence and arraignment yesterday. He's entering a not guilty plea today.
All right, this will be further notice for trial. And Mr. Wright was a plea. All right. Any questions about the calendars?
You're on number 5. We really ought to go ahead and set that to an 11 o'clock calendar for competency.
Our position 5, Destiny Essegibo, is reset to April 4th at 11 a.m. Any others? Okay. Is Mr. Ian Walker by any chance still on Zoom?
He's not on Zoom, but I did reach out to him. He said that he would give Ms. Meadows a call, I guess after court
No.
today.
Sorry. I'm sorry, I was doing something else. Sorry.
Yeah, he said he would give Ms. Meadows a
All
call.
right. This will conclude the.
I think he's got my son.
Just be quiet.
Sorry.
This will be the conclusion of the SAP calendar. We can stop the